if we could please stand before we start the pledge. I'd like to take a moment of silence. This week, Royal Palm Beach lost their mayor unexpectedly. Fred Pinto passed away. So if we could just take a moment and retrospect in respect for their loss and that of his family. That's a good reminder, life is short. Please join us in the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, if we could have the roll call, please, starting with Mr. Palin.
Frank Palin.
Mary Viator, and also on Zoom is Frances Bechtel, a new attorney in our office, but she's just going to be viewing the Zoom proceedings tonight.
Michael Johnson.
Keith Giordano.
Elizabeth Accomando.
Patricia Farrell.
Betty Ardu.
Jay Foy. Burgess Hanson, and then we also have Miss Kim Delaney from the Treasure Coast Regional Planning Council on Zoom. And then we will be shortly joined by Bernard Lebedecker and Jeffrey Pepin with the law firm Reed Berman Lebedecker Pepin.
Miriam Heiser.
Kenneth Lawrence, and also with this is Jeffrey Sisolak and Kayla Heiser.
I apologize. Also Scarlett Camp is on the line.
Thank you. Okay, welcoming remarks, Michael. What you looking out for?
Just like you said, we need to thank everybody for coming, but we also have to appreciate hug our loved ones, because we never know what's gonna happen.
Absolutely. Yes, thank you, everybody, for being here. We appreciate it. If you don't mind, I just want to do a little housekeeping. Just be aware, our website, indiantrail.com, more and more information is being put on there for the residents, just to make it a little bit easier for everyone, so you don't have to call. So staff is doing a great job with that, keeping everyone updated on what's happening throughout the district. Please silence your cell phones if you haven't already. And if you need to have private conversations, please step outside to do so. And when you do step outside, please go. There you go. You get the pass. You get the pass. It's okay. If you want to address the board on any of the agenda items, please fill out a card. They're in the red box on the little table by the door. Put the agenda item on there so it's clear. We know when you want to speak. If it's not on the agenda and you want to speak during public comment time, roughly around 7:30, don't have to put that on there. We'll know to call you up for that. And we just ask everybody to be respectful to each other. Everybody's passionate, and everybody has a right to speak, and we want to hear everybody and do our best for the district. So thank you for being here and participating, because it's really important to everyone that we all participate.
Those are good reminders. Thanks everybody for coming out. I just want to say we've had the equestrian trail meetings, and it's last couple of ones, we've had some hiccups, but we should have a crew, the full crew with us the next October meeting. I've also spoke with Seminole Ridge High School TV production teacher, and they're assembling a couple of students to help us maybe make a video, promotional video for the equestrian area, also to talk about the safety of what to do when you see a horse on there. So they've worked on some signage along the area, some good feedback. I think we're making some progress little by little.
Great.
I don't have anything to say, but welcome everyone.
Thank you. Okay, so we will get right to it, starting with the agenda approval. Are there any additions, deletions, or substitutions? And I see we do have,
Through the chair,
Mhm.
yes, apparently our attorneys are having some technical glitches with Zoom, but we would like to add Mr. Lebedecker and Mr. Peppin to have a presentation and discussion with the board with potential action to be given by the board to Mr. Lebedecker, Ms. Viator, and administrative staff.
oh, do you want to add that to the regular agenda or under other government?
Or is it under presentations?
I think under presentations.
Okay.
Would be
6
good,
p.m.
or as soon as they can
Or
get on.
6-0.
Do it right at
6-0.
the beginning.
Well, if they're not
Yeah,
online,
not
we don't.
available.
We don't know yet. So,
Yeah.
so, maybe just make it 6-4 and
Okay.
just to cover us.
Right.
Good.
Mhm. Make a motion to accept the agenda
With the amendment.
with the amendment.
Okay. Keith.
Excuse me, through the chair?
Yes.
I'm sorry, I wasn't paying attention. I was trying to help the attorneys get on. But did you, the 11.6, did y'all address that amendment?
I'll make a motion to modify the agenda approval to include item 11.6, the Safe Streets for All agreement has a new award number assigned by the state. The agreement printed to president's signature reflects the new award number of 693JJ325400045. This was the only thing that changed in the agreement.
And 6-4 being
Yeah.
Mr. Lebedecker's
As-
presentation.
Yep.
Scarlett, you got that?
I did, thank you.
You are very welcome. And Supervisor Farrell made the motion and Supervisor Giordano seconded. Do we have any comments? Nothing, no comments, right? Okay, nothing, nobody? All right, well, we'll call the vote then. All in favor?
Aye.
Aye, see that it passes unanimously 5-0. All right, Captain Turner.
Lieutenant.
Yeah, she's not.
She's got that.
Yeah.
one.
Good evening, sir.
Good evening, everybody. Captain Turner, PBSO. Darla let me come out tonight, so I get to come see all your smiling faces. I don't really have much to add on the report that you usually get for the traffic accidents. There was one more traffic fatality at the end of last month. A 16-year-old on a dirt bike. 60th and Seminole Pratt went around a vehicle right into oncoming traffic and was hit and killed. We had another DUI on a ATV that was out on the road also right at the same night. So there are some operations we're running up here for the ATVs and the four-wheelers that are on the road using the roadways and the dirt bikes and everything else with unmarked cars and some of our wildlands guys with the bigger trucks and everything. So you will see traffic stops or attempted traffic stops regularly up here with those kids or the adults on the dirt bikes drinking. So I just want to give you a heads up. That's going to be running for probably the next month. Trying to get a handle on some of the issues that we've been having with the dirt bikes and the ATVs. Other than that, I was just making myself available for one of your agenda items later on in case you needed me for anything. So,
Thank you.
Jen, and anyone have any questions? Good.
Thank you.
Thank you very much. Okay, item 6.2, fire rescue update. I believe we have Ms. Banks here tonight, but she stepped out. So we can, we don't have Benny. Okay, I don't want to rush her if she's busy with business. No, okay. So if it's okay, I guess we'll move on. She's got business to handle. Right to 6.3, and I will turn it over to Mr. Foy.
Yes, can we pull up the presentation? Who's handling the video. They carry in the back,
I think they're working on the Zoom.
working on the Zoom. Well, if you don't have the pictures, I don't know how I can.
Do we need to maybe take a 10-minute break so they can deal with
I
it?
think that might be a good idea if we're not ready. Oh,
There.
what's
Scarlett's
that? There
got
it is.
Scarlett's
Ready.
got it, yep.
Thank you, Scarlett.
She's always coming in.
All
Yes, she
right,
does.
do it full screen. But this presentation is about lot storage, the volumetric part, not the duration, not how long the water stays, stormwater stays on the lot, although I will mention it a couple times during the presentation. I'm using the M1 basin as the discussion basin, and go to the next slide. All of you know what the M1 basin looks like. There's an upper and lower basin. It's labeled on the map. We have 3 drainage basins, major drainage basins that aren't in cities. Santa Rosa Groves actually already does have the equal compensating storage requirement. We adopted that because it was so new and it's along with the driveways. The M2 basin has similar results or discussion points that I'll bring up in this, but I'm using the M1 basin specifically to try to explain lot storage. Next slide. All right, this is an engineer's type love it graph, but I only put it in there for a couple of reasons. It's the stages in the M1 basin, upper and lower basin throughout the years for the major storms and for major rainfall. The reason, 2 reasons it's in there is on the upper left, you'll see the upper basin elevation. We have gotten to 22.1 in the upper basin twice. Back in 2012, which was Isaac, and in 1995, right where it says peak, we were also at that same elevation, 22.1. And GVD, I don't know that the data matters to you, but that's the one that we have used throughout the years. The lower basin, the highest it's gotten to was during Isaac, and that was 20.8. I show that because I get asked the question, well, what storm are you designing to? It's not a specific storm, it's what elevation. In other words, we're protecting against the highest elevation in the basin that we have experienced on record. And the only other thing I'll point out to you is if you look at the orange lines, which is the Isaac, the upper left where it says upper basin, the peak of that, the width of it, of that curve going up is not acceptable, but that's how long it takes to come down. It took over a week to come down. But if you also look on the right where it says peak, that was the 95 storms. That wasn't a specific storm. It was a series of rainfalls. Look at the width of how long that took. So when people say to you and me that you haven't done anything for drainage since the 90s, don't believe it. I'll start at the Amel Gate. We had one Amel Gate down. We now have manually operated by telemetry, a second gate that was never allowed to be opened. At 40th Street, we have 6 gates instead of 2, and the 2 were really ineffectual, had to flow over the top. At Roach, we didn't have that structure before. We can discharge over 500 CFS. At the pump station 2, right here near Orange, we have a new bypass that can flow 4 times what the previous one flowed. At the pump station, nothing changed at the 2 pump stations, but at the outfall of the impoundment, we can now discharge 1 inch per day if we're allowed. We could only discharge 1/4 inch before we got variable gates. So there's a misconception that the Indian Trail hasn't done anything for its residents. And the M2 basin, we've added gates that we can control, not flashboard risers where you have to go out and physically pull the boards. So even though we haven't increased storage there, we have done things in the M2, and we're about to let a contractor have more storage in the impoundment as well. So go on to the next slide, please. A box represents a lot. The original calculations as it was submitted was based on these are approximations because it's a little more complicated, but 1 1/4 acre lot is represented by a square there. Typically, you have a 30-foot easement on each lot, 30-foot each lot, so it's 60 foot for the roadway. I didn't represent a canal on this particular one, but you have, my screen keeps going out, but 1 1/4 acre is 54,000 square feet. The lot area without the road is 47,000 square feet, a little over an acre, and the lot area as permitted with no fill is the 38,000 square feet, which is about 9/10 of an acre. You weren't supposed to have any fill according to the original calculations and assumption. What was included was 8,000 square feet of fill. That includes the slope up to the house. And the house and the septic tank and porch, anything up that high, was about 3,000 square feet. The other assumption was there was about 840 square feet of driveway to get to the road. So you'll see the three concentric boxes. The outside biggest box was not supposed to have any fill. If any fill is put in that area and they filled as the 8,000 square feet, you're losing storage. Where does that water go? The next door
door.
neighbor. All right, go to the next.
Jay, do you know, how much does that change if you add another 30-foot easement for, a canal on the side or the back? Do we know?
It can be figured out, sure. I mean,
Because most I think do have 2 easements, don't they?
I don't know if most, but I know a
Yeah.
lot. I
A
know
lot
I
of
do.
them,
Yeah.
not all
Yeah.
of them, but
a lot
I
do
have-
have that, yeah.
3.
That's
I
accounted
think
for.
you have 2. I have 2. Actually, I think I might have 3, but yeah.
That's accounted for in the overall calculations where you separate the roads and the canals and the lots, but I'm just taking one lot as a
Standard.
That's fine.
approximation. Go on to the next slide, please. This is what the original calculations represent, what you would expect. The house on the left of the screen, you see that the house is built up and the entire area between the two homes is at natural grade. And the swale in front for the road is there. There's no excessive fill. Maybe the shed in the back that wasn't anticipated, but that's not going to harm things much. Go to the next slide. This is what's happened. This is about one of the worst cases you can see. From the road to the house is completely filled. And oh, by the way, they have put an accessory building that is extremely large. It's about equal to the house and it's all filled. Where does that water go? Same answer, to your neighbor. All right.
And that road has major drainage issues.
Yes, that was used in a previous presentation. Go ahead to the next. This is the M2 basin, but it represents the point that I'm getting to. How was the system designed? If you'll see the words in the middle left, it says 43rd Road North, right by the N. Yes, thank you. There is a house that is out of the water and the driveway may have a little water on it. That's the way that it's supposed to look by the design calculations. If you look at most of the lots around it, the people have filled their lots and you have nice grass around the house. Now, that's what I would want, but that's not how the original permit was. The assumptions in the permit are not valid with that type of fill. Fortunately, there are some empty lots and they are making up the difference, or other things we have done or have made up difference. But that's what it's supposed to look like, where that arrow is on the screen. Might not be what you want and people might expect something different, but that's the way it was designed. The lots flood, the roads flood, and the house doesn't. That's what it's about. All right, next slide. If you take a side look at the house, you've got the fill, the house, and the swale, and the swale and road is on the left. Go to the next slide. Groundwater storage below ground, in between the soil particles, you get a lot of storage if you have the groundwater table down. Now that is affected when you get continuous rain every day, as you see water standing in all our soils now, but typically you're going to have about 4.9 inches of storage in the soil. So if you had a 5-inch rain, you shouldn't expect much runoff. Hit the next slide. On the lots, you get another 4.9 inches. Now it looks like it's a lot thinner because the soil takes about 3 feet of soil storage to get that. Whereas on the lot, the 4.9 inches takes about 6 inches because it's getting runoff from the roads and from the houses. So it builds up about 6 inches, but it's 4.9 inches of rain. Next slide. On the roads, we store about 1.5 inches. I think that, yeah, 1.5, and before you get to the finished floor of the building. Next slide. On the canals, we store another 2.8 inches. All right, next slide. In the canal. We also have an impoundment in the M2 basin that is 1.3 inches of additional storage. Next slide. We have about 0.3 of an inch discharge. Now you're in the calculations, you're not supposed to use that discharge. It's a glass wall theory with no discharge, but you get it, so I included it. Next slide. That means the original design was for 15.7 inches of rain, or 15.4 if you want to not take the 0.3 credit. Back in the 80s, that was about the storm used for the 100-year storm, around 15 inches. So that's very consistent with the way the permit was issued. So it's designed to handle 15 to 16 inches of rain. We got more than 17 in Isaac, so we actually did pretty good, as I only heard of potentially 2 finished floors that got hit. The next slide. What's new since the permit? Well, there's a couple of things. We have lowered, this is another thing we've done for drainage, we've lowered the control elevations in the canals from 17 to 16 and 15, according to whether you're lower or upper basin. That provides another 0.7 of storage in the canal. So that's something else you can say to the residents, we have done for you through permitting. We now have the facilities, as I mentioned earlier, the road structure and the outfall at the impoundment and the 40th Street structure on the Emil Gate to have pre-storm drawdown. That allows us to get rid of about 1 inch of rainfall from a rain before the storm hits. We've also got 0.2 of an inch additional discharge we got in 2016 through pushing the settlement that we had in the late 90s. Sum all those up, we're up to 17.6 inches of rain we can take if the lots stored what they were supposed to store. All right, next slide. We have the 640 acre impoundment plan. That would give us another additional 1 inch if it's above ground. Next slide. And I called this one iffy, the next slide. If we go to because the iffy is if you excavate the impoundment, you get another 1.3 inches of rain that you can store in that excavated impoundment.
So that'd be 2.3 total, or?
Yes, 2.3 total, and you're up to 19.9 total amount of rain you could have before the houses flooded. But here's the but. Next slide. If people are filling, and I used a 3-inch fill because you lose groundwater storage under structures because the soils come back, and you store a little bit, but not much. And people are starting to fill, you lose the surface storage. So I used a 3-inch just as a reasonable worst case. You take that 3 inches off of what the design was, 15.7 minus 3, you're down to 12.7. That is like the 25-year storm. That would be horrible finished floor protection. You take that same off of the new things, we're up to 14 point, this is small, 14.6. You're still not up to where you should be. When we add the new impoundment, you're where you started. If everybody fills to where they are going right now. And if you get a little bit more, you're above actually the planned design. So that's what storage is.
Can you clarify on the roads, when you said there's a certain amount of storage there, is that based on a dirt road, milled road, or paved road, or is there any difference?
The way the calculations are forced by the Water Management District, any road surface is considered impervious. You get 0 storage in the road, so it's all on top of it.
Okay. So even back then?
Even back then, they required you to consider that as
So we're not,
solid ground.
what I'm trying to make here is that we're not taking away any storage that would have been calculated for dirt roads versus paved roads.
It's the exact same calculation.
Yeah, I just want that.
That's true. All right, next slide, and we're getting close to the end. The question is, what could we ask Palm Beach County to do? And we have, but they have not gone quite with the recommendation. There are three things that I suggested to them about a year ago. The first is, since the assumptions were about 80% of the lot was to be not filled. If the permit comes in and it's only 20% or less of the lot, you don't need a fill permit. You're good. Stop right there. This is what Wellington uses, by the way. The second option is use a pre-post storage. In other words, we're not trying to penalize anybody who is already there and tell them, well, if you want to add a garage, you have to dig out for the, not only the garage, but your house was already too big. So typically you would allow them to just, if they want to put a garage in, then they have to lower an area just for the garage, not for the other existing non-conforming uses, if, to put it in zoning type language. That was the next slide. And the last one on this slide is, that was that one. The last one is you go through some engineering calculations. I'm not going to go into what they are. Just at a certain elevation, you don't need any storage. When you get up to the next foot, you need more. And when you get up to the next foot, you need more. And that's equal compensating storage. So at the elevation of the I mentioned earlier, the 22.1 or 20.8, you have to have the same or more storage before after as you do before. Oh, I'm sorry, that was pre-post. So this is a calculation that matches the permitted calculation. The reason that's important is if you have a low lot, you don't want to tell somebody that they have to do pre-post, because that means that all their lot's going to be flooded, just like it always has been. But they can use the calculation to fill by the permit. I hope that wasn't too confusing. Next
Oh, you're
slide.
Happy to the end.
Yeah.
engineers speak.
Well, I don't want to get into the calculations because that's what an engineer is for. We
Right.
don't have many uses, but that's one. All right, the next slide, please. I just wanted to address the duration of flooding a little bit.
Is there a way we can make it bigger? This last page?
We got two more slides and it's just pictures, so you
Okay.
could see those.
I don't think Scarlett heard you. or it's
Scarlett, next
frozen.
slide, if she's controlling it.
I'm sorry, I froze, so I'm working on it.
I literally picture freezing.
There you go. All right, the next slide, I'll explain what it is it's a cylinder with a small cylinder in, oh, there she goes. If you have volumetric storage, equal compensating storage in the basin you're in, like we do for commercial, or like we have adopted for anything that's not AR in M1 basin, or M2 basin, or Santa Rosa Grove, as long as you have the same volumetric storage and the same discharge rate, the duration of the flooding stays the same because you have an increasing amount of water you have to get rid of. Now, that's not true for the single family houses that are filling up the storage, because now it like bubbles over the top of that glass. The next slide is what happens when you take something in from the outside. Well, if they have equal compensating storage, the volume is the same, it results in the same stage. It doesn't get any higher, but because you're taking more water through the same limited discharge, it takes longer to get rid of it. So the duration gets longer if you take water from an outside. I'll give you two examples and then any questions. When we allowed Bay Hill, or Bay Hill became an activated unit, we had a discharge of 232 cubic feet per second in the M1 basin. That's square mile and a square mile and a half, 1.5 square miles, had a discharge of 42 CFS. The South Florida permit was increased to the 274. So that did not affect the duration. However, I can't find anything for Rustic Lakes or the property we took from North Lake for the county. And in unit 19, I don't find anything that increases our discharge. Because we've taken some properties outside, they are extending the time it takes to pull down, but Bay Hill did not.
Through the chair.
Mhm.
Is it not true that in those agreements, we required as part of activating the units that there be an increase in the permit with South Florida?
We added that to the North Lake corridor as a condition of the agreement, but we did not have that in the unit 19 contract. And I couldn't find anything in Kramer or / Rustic Lakes that said that. The only one I found that we required an increase in discharge was Bay Hill. And I know we didn't do it for the Palm Beach County property on North Lake that was not in the district.
So the one that's in front of Rustic Lakes, the one that recently contacted us, that one, the landowner agreement does require an increase in the permit. And that was required to be done shortly after that agreement was signed, which was, I don't know, 20 years ago. Yeah,
Yeah, that is in the agreement and they will have to.
but is that agreement even valid at this point? That's a whole other thing, but,
Yep.
yeah. It was my understanding that whenever we took on those, that we actually, or the district at the time, had increased, required that as an agreement, a requirement of the landowner and South Florida Water Management.
I did find that in that, what we call the North Lake corridor. I don't remember the legal names of the properties, but the ones
Yep.
north of Rustic Lake.
Okay.
Yes, sir.
You were talking about over the years, people are filling their lots a lot more, and that's causing the rise of the water and also how long it takes it to dissipate. One thing that I've always looked into too, that we used to do, is people are clear cutting their lots, and some trees are one of the best sources of drawing down water because they absorb water. You're saying, what can we get the county to do? We need to bring back that people can't keep clear cutting their lots because those trees are very valuable to the sponging of water.
I agree. I'm not gonna, some trees have a very high transpiration rate because they have more surface area. Yes, that's a true statement. They won't affect your peak stage, but they can affect pulling down the water between storms.
So you were saying.
I'm agreeing with you.
What you said, what we can get the county to do, well, the county can enforce what they should be enforcing, and maybe not enforce what they shouldn't be enforcing.
I'm not an expert on the landscaping codes in the county, but
Okay,
I
thank
haven't-
you.
No, no, it's sure that's not something we can look into. Because it used to be that, you could only cut down so many, what you cut down had to be replaced if it was non-native, so.
Right, they
Maybe
used
they
to
need to go
find
back to
people, when I first moved out here, someone I think that has that property on North Lake cut down too many trees, and he was fined like $50,000 for cutting down too many trees.
So maybe that's
So we
something
can-
we can look into.
I just would say that encoding for enforcing code,
Hmm.
what they should and shouldn't be is subjective, because if code is there, it's there for a reason. So they can't selectively enforce one thing and not another. So,
No, we're talking about
Yeah.
the trees right now.
Making
They didn't
changes,
enforce the,
right.
Yeah.
Enforce the rule that people can't clear cut their lot. And
Or
if they
go
did,
back
they gotta
to-
plant so many trees to compensate. Because that is a big drawdown of water
And shade.
and shade, which helps with the global warming that some people worry about.
Okay, any other questions?
through the chair, Jay, this is what our permit was based on. How do we get to a point where, we can see what we actually have? Because we know, I mean, all of us who can drive around, we know that the conditions throughout the district have substantially changed, and every time there's a permit issued, right? That has an impact. I know that there are people in our community who don't really understand that. They're saying, I never I never had water sitting in my swale for the 25 years that I've lived here, right? But now suddenly they've got water sitting in their swale and water's not moving off of their property and they're seeing things that they never saw before, but it's all connected. Water is connected to water, right? How do we get to a point where we can assess what the actual current state of the district is and the current need so that we can set goals based on those changed circumstances? Because no matter what we do moving forward from here, advocating for the county to make changes, we still have what we have. And it's obviously not sufficient. So is that like a full-blown engineering study that we have to bring in another engineering firm to do, or how do we get there?
We update the studies each time we do a storm modeling, and the last one we did was for the East-West Canal, which is very recent. It was based on the LiDAR data, the aerial photography of actual land elevations. I can't remember the year the LiDAR was taken, but it's within the last 10 years. That's what the FEMA maps are now based on. So we do have an accurate picture of where we stood at the date of the LiDAR, whether it was 2016 or 18, I just don't remember. But we have an accurate reflection of where we are, and our defined level of service to bring the canals down to a certain elevation within 3 days after the storm. We analyzed that in the modeling runs, and we supplied that to the grant people, DEP, this year. I think it was in March of this year. It's not 100% up to date because you don't fly LiDAR every day, but we have one that's at least within the last, well, I'll say 10 years. It's probably more recent than that.
But even since 2016, there's been
Lot.
significant changes
Yeah.
and,
Nearly every lot is.
you know,
And a lot of fill since then has been brought in.
so can we,
And then how do we address that with our permit? I mean, we've got more people now, so we're based this on a permit from the 80s, you said, right?
The original permit was issued in the 80s. We've
Right.
had modifications.
Right, and
since.
how many homes were out here in the 80s compared to what's now? So how do we
Yeah.
go back and maybe adjust that permit?
but the original permit counted on houses being on there, but based on what he showed us at the beginning, that's not what we have.
Right, right.
Right.
Yeah, it assumed
where-
100% development. That's what you have to base your
Right, but-
calculations on. So we do know where we stand relative to the results, and we do know that with the 640 acre impoundment, we meet that above ground, not below ground, not the dugout one. We meet the defined level of service for the 10-year 3-day storm. So we know exactly where we are based on the LiDAR that was around 2016 or 2018, whichever the date was.
When you had your conversation with the county on what they could do to help with this, what was their response?
This goes back about 5 years. We've been trying to get them to change their codes to meet the requirements, and they have. But what they've done is a combination of water quality and berming around the property so you don't affect the next neighbor. However, the berms are not to the 100-year storm, and what happens is as soon as it builds up to the 3-year storm or whatever that design is, it goes to the next property, and the fill actually causes more flooding on the next property. And it's gone through some iterations, but it's not equal compensating storage right now.
So they were open to adjusting what was needed.
They have adjusted. They haven't gone to where I believe they should be.
But water's still being pushed to the swales though.
They have, their current plan shows berming around the property, some detention, and the water all goes to the front swale.
So we're still,
It's still gravitating.
the more that you pave over and build over, the more water that has to be discharged from that property that's going into the system. So can you put together for the next meeting a proposal on how we can get I think we need something current, like up to date. Idea of where we're at and what we need. Or at least how do we get there, right? If we have to hire someone, proposal, what does that look like? Because I think, we can't ignore this. This is a significant problem.
Yes,
So-
we have the modeling in-house already. We can do it. The issue would be, when can we get updated LiDAR data? I don't think that the district would want to pay for that, but I can investigate that to see how much it costs. 'Cause
Did we do it? We did it, you said, for the east-west canal?
It was the
Yeah.
county LiDAR. The county ran the entire county and have topo for the whole grades, elevations for everything.
How often does the county do that?
They did it for the FEMA studies, which, by the way, was very effective, because if you look at the FEMA maps, the houses are out of the flood zones, whereas before they did that, they were in the flood zones. So as the house gets built up, they clearly show that on our flood maps that the houses aren't flooding. That's not to say that an insurance company or a bank won't require you to have flood insurance, but it does show that your house hasn't flooded.
I have an idea. If we were to take the data that you had from that and we're to one of the things I mentioned at the last meeting was that the current, what the county is allowing you to build on is actually way more than what the water control plans were based on. So if we were to make some assumptions, right, worst case scenario, what is currently allowed, where does that put us? Right, so
Yeah.
you take your same modeling based on what is currently allowed on every single property.
Yep, we can do that. That's a
Okay.
bunch of assumptions, but that could be done without the massive LiDAR data.
It certainly, it then gives us a side by side. Here's what the water control was planned based on, and here's what you could be doing today under the county building code. And it gives us at least some direction on where we need to go. Without having to spend all the money on the LiDAR.
Yeah.
I think the county is planning on doing more, because after they did the recent floodplain, I think they're looking at the rest, so for the next hit. Okay,
Okay, I can do that.
thank you. Michael? Did Lebanon?
Yep.
Okay.
Yeah.
All right. Thank you, Mr. Foy. I appreciate the information and I hope everybody out there understands that we're doing everything we can and
If you take anything home, we've done a lot.
yeah. Yes. So I appreciate that. Do we have Ms. Banks back in the room? I don't see her. Okay, no, okay. All right, I guess we can move on to 6-4, Mr. Lebedecker
And Mr. Pepin.
and Mr.
also on.
Peppin. Good evening, gentlemen.
Good evening. I'm assuming you guys can hear me but not see me.
Correct.
Okay, because I am getting a message that I can't start my video because the host has stopped it.
Scarlett,
That would be Carrie. But
Oh.
I don't think we stopped the video.
try it again, please. Benny?
We lose them all together now?
No, they're still on.
No.
Let's see.
I see him, the participants.
I can hear you guys. I still don't have video.
Can you turn your video on now? He said that he turned it on.
No, it still tells me the host has stopped it.
Okay.
Share screen.
Guess we'll just go on. Can hear him.
You guys want to just do an audio? I'm not the best looking guy in the world anyway.
Yeah, yeah, Mr. Lebedecker, just go ahead and proceed without video. for
Okay.
him Up and
For the benefit of those who do not know, we have been dealing with an issue between the order that was entered by the court and ultimately the final judgment entered by the court, and what, in my opinion, and I do not speak for everybody on the Board of Supervisors, and I don't even think I speak for all of the lawyers, has been an effort by the county and individuals within the county government to use political levers within the county government as a way of attempting to undermine or strike back, and I know those are strong words, the district for seeking a vindication of its rights in court. And this has not been a new issue. During the litigation, we ran into a situation where Sarah Baxter had solicited from a letter from John Carter, who was then the vice president of the Minto Project. And at Sarah Baxter's request, Mr. Carter sent a letter to Sarah Baxter that complained that the district was not willing to meet with Minto, discuss with Minto, or try to, there we go, or try to resolve with Minto the issues in the lawsuit. I'm not going to go into detail as to the efforts that had been made prior to that letter being sent by Mr. Carter to Sarah Baxter at Commissioner Baxter's insistence. I will tell you that after the letter was sent, we met with Minto and Minto's lawyers at their offices, myself, Burgess Hanson, Mr. Berman, and we discussed the fact that ITID and Minto together should jointly lobby the county to build out 60th Street, because it was generally believed by the traffic engineers who were deposed during our case that if 60th Street was widened to 5 lanes, that would be sufficient to accommodate the traffic for Minto, and they would not have to connect to Persimmon and use Persimmon as a highway from their project to downtown West Palm Beach. We met, there was an agreement that Minto would do that with us, and we never heard from him again. In other words, once Minto had written the letter that Sarah Baxter had requested, painting us as being intransigent, there was no effort to resolve the case. We were willing to do so. We proceeded to get 2 summary judgment orders and a final judgment. We know, based upon documents obtained from the county attorney's office via public records request, that on or about bear with me, I'm waiting for the on or about March 22nd of 2024, a gentleman who worked for Sarah Baxter solicited a opinion letter from the county attorney's office. And the county attorney's office subsequently drafted an opinion that stated two things. One, based upon a finding by the court that our roads, ITID's roads, are not public within the definition of the state highway statutes, that the roads were therefore private. In other words, if it's not black, it's white, which is rarely ever the case in the law. But since the county attorney opined, the roads were found not to be public by the court within the meaning of that statute, they must have been private. And because they are private, you can't use public funds to maintain, repair, expand those road networks. And because they are private roads, the sheriff does not have jurisdiction to enforce traffic laws within the district. We were provided a copy of that opinion letter, which was drafted by a gentleman named Darren Lester. Darren is an attorney at the Palm Beach County Attorney's Office who used to work for Longman, Lewis and Walker, which is the law firm that represents Minto. I'm not sure why he was assigned that particular job of writing that opinion letter, but certainly he wrote it in a manner that assisted his prior employer's client. We disagreed with that opinion, and we believe that that opinion is not a legal opinion, but a political opinion. It is undisputed that the district is a public entity. It is a public body, no different than the judges in the courthouse or the county commission. And that's expressly set out in statute that we are a public body. And it is also very clear from looking at Florida law that a public body cannot have private property. It can regulate its property, just like, the judge isn't going to let you do whatever you want to do in his courtroom. It's still a public courtroom. We believe that Florida law makes it very clear that, one, the sheriff has exclusive policing jurisdiction throughout unincorporated areas of the county. And that statute that gives him that jurisdiction specifically states the sheriff's jurisdiction and powers must run throughout the entire county, regardless of whether there are incorporated cities or other independent districts or governmental entities in the county. And the sheriff's jurisdiction is concurrent with any city, district, or other law enforcement agency that has jurisdiction in a city or district. Similarly, Florida statutes provide that counties have original jurisdiction over all streets and highways located within their boundary. Finally, the Florida Traffic Code has a definition of a private roadway, and it provides that a privately owned way or place used for vehicular traffic by the owner is a private roadway. Well, our roads aren't privately owned because we're a governmental entity. Subsequent to that opinion letter and our response, we had 2 meetings with the county attorney's office. They have refused to change their opinion. We have also been provided with letters of complaint that were drafted anonymously and sent to FDOT, and now apparently not only our bond underwriter and counsel, but in the letter that we obtained, the writer of the letter says that they have sent a copy of the complaint to the IRS and the SEC. And the complaint is the complaint that Sarah Baxter and the county attorney have made all along, which is that we are using public money to build private roads. And we are using public money for the benefit of private people. It has gotten to the point where I think, and I've dealt with things like this before, if you sit back on your heels and you don't say anything and you don't do anything, the people who are attacking you are emboldened and they feel like they can continue to prosecute what really is, I think, a political effort to get Minto the roads that Minto could not get through a lawsuit. I believe, based on the complaint letters and the detail that they go into, where they quote from transcripts of depositions that were taken in our action, I believe that where they look at documents and exhibits that were used in our lawsuit in detail, whoever is drafting these complaints is intimately familiar with our lawsuit and is either being fed that information from a lawyer that represented Minto or has gone to the court file and has read it in detail and obtained copies of transcripts and things like that to draft these complaint letters. We have no guidance from the board on what to do in the face of this. I can tell you that I met with appellate counsel today for about 2 hours. As you know, Minto has appealed the lawsuit. Mr. Burlington, appellate counsel, thinks we have an excellent case. He thinks it's actually a very simple case. And he was also aware, by the way, when we met, that there was a sort of a political aspect to this. You know, Minto's a powerful company. It's worth billions of dollars. And the unfortunate reality today is that there's a lot of lawful ways for that money to find it to politicians to help with them with their campaign, to help with their super PACs. And really, even now we know, for instance, like with PACs, it can find its way into the candidates' personal finances and personal pockets. I am concerned because what I see happening is the victory that you paid for and that you fought for is going to be undermined by county officials who did not want Minto to lose that lawsuit. And the most telling thing to me is this. The county attorney approached the sheriff and said, you guys have to stop doing traffic enforcement within the acreage and within Loxahatchee Groves. They have not gone to Minto and asked Minto to pay the $18 million that Minto was supposed to pay pursuant to the approval that Minto obtained back in 2014 or 2016, I forget the year. We are not being treated the same as other entities and organizations in Palm Beach County. If the county attorney and Denise Kaufman really thought that that order made our roads private and therefore the sheriff had to be yanked, and stop patrolling for traffic violations in Loxahatchee and the acreage, I would have expected that public official to also have gone to Mento and said, you lost the lawsuit. You're not connecting to Persimmon as required in the resolution approving your project, and therefore you have to pay me $18 million. When we raise those issues with Denise Kaufman, she refuses to explain why the county has not done that, even though they're taking action against us, and explicitly telling us the reason we're taking action against you is because you obtained a judgment. We are seeking guidance from the board, and we believe that these facts should be made public to the residents because there is an election coming up. And this affects them, and they have a right typically to know what is happening where they live. I'm going to stop talking now because I think I've been talking long enough. And if somebody has questions, I'm ready to answer them.
Through the chair. I'd just like to clarify that any actions the district take wouldn't be on behalf of the election. It's to inform the community so that they know what we're dealing with. But
People in the
challenge-
community, I don't mean to interrupt, Supervisor Argue, the people in the community are going to make a vote. They're going to cast a vote. And that should be an educated vote based upon what is happening in their community. And this is affecting them. So, no, we are not going to influence the outcome of an election, but I do think as a public board that does work in the sunshine, having dealt with this now since April of 2024, when the first opinion letter came out from the county attorney's office, folks should have that knowledge that this is going on when they go to the ballot box.
Mr. Lebedecker, I absolutely agree. I don't think this is the year that we have to worry about that item in particular for the election, but I do think it's critical that the message has to get to the residents so they understand not only what's been going on, but what we're up against today and coming up against us in the future. I'd like to see a resolution from the board with some information to be released, not only to the community, but to our neighboring cities and the county, with, and forgive me, but non-lawyer speak where everyone can understand, not some legalese, as they say, exactly what we're dealing with and exactly the definition of our roads. Because I see it all the time on social media. I have conversations with people and people don't clearly understand. And, we were left to be quiet. So I'm grateful now that we have this opportunity to bring this to light to the community, to all the residents, because they deserve to know. And I understand that we couldn't until this point, of course, but now is the time. And I think it would clarify a lot of things for not only the residents, but the other entities that we're dealing with. So I'm going to leave that obviously to you and Mr. Hanson and Mary and Frank, our attorneys, but to put something together that we can put out and clear this up. I think it's important, what is the definition of our roads, right? Nobody seems to understand that, as you just mentioned. And like I mentioned, neither does the community. So I think this is something really important that we need to do.
Through the chair.
Mhm.
So actually that's where I was going, but I wanted to make it very clear for the record that whatever we do and have been doing has always been about this district and the residents in
Yep.
this district and protecting our taxpayers. And this lawsuit in particular was very important to establish and to finally answer that question about the roads. So what I would like to see in a resolution is adopting essentially what was in the court order already, and to provide direction to staff, which would include the attorneys, litigation attorneys, engineering, and the executive staff as well, to have the authority to defend and assert our rights as set out in the lawsuit, and to take any and all steps necessary to defend and assert the rights of the district. And in addition, the one thing that keeps coming to mind when I was listening to you, Benny, and of course, I've been thinking about it for the past little while, is that these things are starting to seem like a frivolous complaints and nuisance complaints. And there's been plenty of law that's been put in place in Tallahassee against the individual from doing that to public bodies. And I would assert that Minto is an individual. Citizens United thinks that they are, because they're allowed to make donations and do whatever. So this is a private entity that is making frivolous complaints and going after a public entity and costing us tax dollars. The judge, we have a final order. It's already been asserted. And I think that we need to stand strong in that, and we need to defend it at every step of the way. And I think the staff need to have the authority to do that without having to draw it out. And, you know, and I agree. I feel like we've had a gag order. We can't talk. We can't even defend some of the things that we're doing because of, we can't talk about what's going on. And I'm over it. I think the time is now. I think that the community deserves to know what is going on and the kind of pressure that we're on. I mean, we've got Palm Beach Gardens annexing property, and they're going to be building high-rise apartment buildings on North Lake. We're going to have the same thing at Southern and Seminole Pratt. And if you think they're stopping there, I have some swampland to sell you if there's any left in Florida. Seriously, you know, it's
Based
time
upon
that
Mr.
people wake
Wayne's
up.
presentation.
And not for nothing, but anyway, I'm going to leave it at that. So I would like, do you need me to word that in the motion?
I don't think we
It's a
need a
resolution,
motion.
right?
We don't need a motion for that, do we, Mary?
Yeah.
They have a motion to authorize.
I want to make sure it's
Okay.
formalized.
Okay.
So that there's no
With
question.
requests.
Yeah. So I'd like to do a motion to direct staff to bring a resolution back to the next meeting. Are we having a meeting between now and the regular October meeting? Or no? Okay. So the verbiage regarding the court order, what our arguments were, what the court agreed on, which was pretty much, it was everything. So if we can lay that out, make it very clear. We can have the layman's term one done separately. But I'd like to make sure that it's very clear from the legal perspective in the resolution. And then in addition, direction to staff as part of that resolution to have the authority to defend and assert and take any and all steps to defend and assert that judgment and those from the lawsuit, which is going to be set out in the resolution. And then-
Needs to necessary to defend.
Yeah, I said to defend and assert, and to take any and all steps to
And,
defend and assert.
The actual status of our roads, what our roads are, that needs to be in there.
Right,
The explanation of that.
Right.
through multiple statutes because they're looking at one
Right.
and not, they're taking
But-
little bits and
But
pieces. So,
that's already part of the lawsuit arguments and then the
but
court order.
it's being ignored. So I think that
Okay.
needs to be in there as well.
All right. And then the frivolous complaints or what, anyway, that comes into
Into
any
the
and all
second,
steps.
right?
I'd like to add to your motion because the lawyers did say about education. Because of the PACs
Right.
getting involved in this election. This is very important. The election's in 2 months, as you and I have known personally. The PACs have gone after us very viciously.
Separate and apart
As-
from that, I think they deserve to be educated, period.
Well, yeah, that's what I
Right.
said, educated based
Right.
on the PACs that are spreading the lies, like Jay Foy said.
Well,
We have been doing a lot.
we can, Mr. Hanson, you can work on that administratively, with council, what to put out and how to put out. We could put something on our website. We could do social media. That seems to be where most people are looking. Won't cost us any additional money. So if we can do that education there and utilize, some of our other assets to work on that education, that would be fantastic.
I second the motion.
Okay, so. Ready? All right, Scarlett, you got that?
Yes.
Motion?
We
Okay.
didn't call the question.
Not
Do
yet.
we have to have public comment?
Do we need public comment on this? We do. Okay. I'm sorry, go ahead.
I know there's one more meeting before the FOSD quarterly conference, but because Ms. Argy sits on that. And I know you've had conversations, so I'll let you talk about the letter to the executive board.
Well, I was kind of thinking that falls in the any and all steps,
Yeah.
so I don't think we need to really go into that.
Okay.
But it will be done.
It's any and all steps.
Yep.
Yeah.
Okay,
And just for clarification, I don't have to wait for the final resolution. I can start on this.
correct.
tonight
That
after
is
the
my
meeting.
intention.
Is my intention as well.
Yeah, I just wanted to be
Yep.
clear for the record.
Okay, yep.
But we will ratify the resolution at the next meeting.
Do we-
So public comment,
Yeah, I'm just,
because it wasn't on the agenda.
right,
I
so,
don't think, we're not gonna, I don't. think-
okay. So do we have any public comment on what we were just discussing? All right. Pia, if you don't mind, come on up, but just do me a favor and you have a card in your hand.
I don't want to do that.
Oh, okay. Well, you'll fill out a card for the record. Thank you so much. Just your name and please
Pia
for the record.
Scorin And Pia Scorin.
That's,
So is it correct? We don't have police coverage?
we
now?
do,
We do.
we do, we
Yeah.
do. The
How
sheriff
did
was not
you-
going to leave us without police.
Okay, so simply by.
We've been
virtue-
working on it, yeah,
Okay.
for months.
And my other question is, so if the roads are considered private and they want to yank our police protection, why can't we close them off to them?
Because they're not private, and that's why we need to clarify this.
But maybe we want them to be private.
They can't be. They can't be because the easement is given to a government entity. And this is why we need to explain all of this, and that's why we're gonna have everybody put this together for everyone, so it can be explained clearly.
So I'm just gonna throw this out there. Strategy wise, maybe you close the roads and bring them to the table to negotiate, because they need a little bit of hard love here.
Thank you. Oh, careful. Anybody else? Karen?
Karen, is this you? Is this you that wanted more? Is that
Well,
for
you're
this
talking
item?
about it now, it came up in the conversation about public, so really I just had one clarification.
So that's regarding this
Yes,
clarification was this. Okay, thank you.
I just want some clarification, just from each of you. This board now and in the future, whether you become a municipality or not in the future, that you will not, and I want it for the record, you will not use adverse possession to take any of our road property. Because that's the problem. The public doesn't understand the difference between easement and ownership. And there is, by the way, there's an attorney general opinion that really talks about a landmark case. I think it was out of Kansas. But it's basically the same throughout the US. Florida isn't too much different for the standards. You had a private parking lot that allowed traffic to go through. So even though it was private property, it was allowed to be maintained publicly. So there's a big discussion, I forwarded to you, but really people don't understand that. And while you have an easement, and that makes us public because it's a throughway to major roads, they are privately owned. So what can I get for assurances that you're not going to take it by adverse possession? Because there have been municipalities and governments that have done this in the past. And Betty knows this is an issue with me, and it's with any of us that own this property. Because with a little over an acre, you don't have an acre anymore. And with per square, but how homes have gone for and the taxes that we've paid. So what can you tell me tonight and to the rest of us about that? Adverse possession, in case anybody else knows, is when you can just take the land because you've been maintaining it. You know, all this milling and stuff, it doesn't look good to some of us because it looks like that's what you're doing. You're doing something, and all it has to be, one of the tests for adverse possession is that we all watch and know what's going on and don't do anything about it. So this is my official, I don't want it to happen. You want it, you take it through eminent domain if you have to. And that's what we told Mr. Carter. He doesn't want to pay the millions. The county doesn't want to pay the millions. The homeowners, I'm sorry to say, are stuck between you and them. We don't like either what you guys are doing, either one of these. Because I think that calling them public roads kind of loses something there. And there are enough cases from what I found that you have good standing, just stick firm with that. But remember, you know, it's our property and we've paid a lot of money for it over the years, some of us, and the value. So we expect that. So yeah, again, I'm waiting. Are you going to clarify that you will not do this? Put it on the record.
Through the chair.
Good.
Mary, can you please, are you prepared to discuss adverse possession?
Yes, but I don't think it's really appropriate tonight to have this kind of conversation.
I do think it's important for the board to actually have that and address this because this keeps coming up. And the difference is that Ms. Mink, with all due respect, you say they're private roads. We have not argued that they're public roads. We've argued that they're not publicly dedicated
Right.
roads and they're not private roads. They are district roads, which are different.
Traversed
And
by
that's
the
No,
public.
you have a
It-
governmental easement,
right.
but it's still private property. and we
But
don't
it's
want
not
it
a
just
private
taken.
road and it's not a publicly dedicated road. Now, we do have some publicly dedicated road. That's another misinformation that's going on out there.
Mhm.
Our lawsuit never said every single road. It said the roads in question were that. So that's another thing that needs to be clarified. But in terms of adverse possession, that's when you're going outside of that easement and
No.
you're using private property that's not subject to an
No,
easement.
that's not true.
And then you're trying to make that yours. And that's what happened in another entity that is often used as an example. That's not what we do. Everything we do is within the easements that Indian Trail holds.
And that has
By
happened where
statute.
easements have taken over the property. There are a number of cases. One is in Kansas, if you look it up, where it has happened. So yeah, because if they decide to take it for the roads, rather than go through eminent domain, which is very expensive, nobody wants to do it, which is why as landowners, we're pretty well protected because we're unincorporated. And if anybody wants it other than Indian Trail, they can't. They'll have to pay.
Well,
But you
that's
guys
why
can get around it with
Mary,
the
can
adverse
you-
possession.
Yeah.
I feel that.
Okay,
way.
we've
So
heard you. I've asked the attorney, please.
Mary, go
So
ahead,
thank you.
please.
I think under these circumstances, let us go and prepare the resolution and then we can have that. And if there's additional questions after that, it can be addressed.
Okay, so we could, this is something we'll bring back next month.
Right.
Okay,
Yeah, because I
fair
like to
enough.
See a policy where you guys need to make the rest of us feel comfortable is that that's not going to happen. And I'm not even talking about now, I'm talking about in the future. Because this may change, we may be incorporated, we may not. I
Right.
wouldn't want to see
We've-
it, but you don't know what's going to happen in the future. For many of us, that's an issue. So-
Understood. Thank you.
Right, Thank you.
Anybody else? No? Okay, then I think we could call the question, Mary.
Yes.
Okay, do you want to repeat that motion. Scarlett, do you have the
She
motion?
has it. right,
You have
we
it,
had
you're
the
good?
motion in the second already, so we're
Yeah.
just
Okay,
going
so
back.
you're good? Okay, all right. Just want to make sure. All right, so everybody in favor?
Aye.
All right, see that passes 5-0. Mr. Lebedecker, thank you.
Thank
Mr.
you.
Pep-
Permission to be
still there?
excused, ma'am?
I'm sorry?
Yes.
Permission.
Yes,
to be
yes,
excused?
you may be excused. Here's your whole pass.
Thank you,
You
guys.
guys have a
Thank-
good night and thank you for giving me your ear.
Thank you.
Bye-bye.
Good night. Okay. All right. Moving on. Okay, off to the regular agenda. Item 7.1, for the board to consider the installation of new guardrail on boundary road segments of 162nd Drive, Sycamore Drive, and 180th. Mr. Hanson?
Yes, thank you, Ms. Akamundo. So just quickly, we spoke about this.
I'm sorry,
No.
we're just clarifying something. This is not on this is on the agenda, but that's not. I would make sure that that'll be during the regular public comment. We just have to adjust your card. Okay, I'm sorry. Go ahead, please.
No, you're fine. So, so as you know, at the last meeting, we discussed and we discussed in subsequent meetings that staff is recommending, and with the attorneys, Mr. Lebedecker and Mr. Peppin, that, you know, we take the necessary actions on 162nd and East Sycamore Drive, because we are having right now just ATV side by side cut through, but we're also having entities within Loxahatchee Groves cutting onto 162nd, ruining the road, ruining the sidewalks, things of that nature. So we're recommending that we put in the guardrails along East Sycamore Drive, 162nd Drive, and transfer those funds from the fund balance to pay for that. Right now, we have them as new, but when we move forward with a project, if they have used guardrail material, then that will substantially decrease this amount. So for East Sycamore Drive, we're asking that the board allow us to transfer $74,120 from the fund reserve. And then for 162nd Drive North, for that length of it. And remember, there are certain properties along there that are
We've
part of a
not.
settlement
Yep.
from several years ago. But that cost would be $317,120. Again, if we can get used, and that includes the installation as well. We do not install guardrails. So if we can get the used, then that will go down maybe even by half that cost. And then we also included on here for 180th Avenue, which, you know, we've not received any permits for that length of roadway between Tangerine and the new 60th Street. So that would come out of the R3 bond money, and that would be approximately $74,120. We're just putting it on here so it's on the record, because technically it's really part of the overall project for that. But since we cannot give legal access without a permit.
Through the chair.
Mhm.
When you say fund reserve, is that the unit?
So it would
Because-
come out of, yes, we would take it out of the fund balance for roads. So that would be unit, what is that, unit 3, I think,
Unit 5
or
or 12?
no,
No,
unit
5.
12 is empty.
6, unit
Yeah.
6. It's unit 6.
No, oh, for 162nd,
Mhm.
yes, I'm sorry, yes, yeah.
So it's coming out of the unit reserves.
It-
And how much is that leaving in that reserve?
I'll have to.
Because
go
that's
back and look.
depleting it
Yeah.
and I do have a question
Yeah.
and I agree with doing this, but
Yeah.
on 162nd, isn't there like a ditch between the sidewalk?
Part of it, but that gets closer to the north where there is that ditch. That's not our canal, that's a ditch on the Loxahatchee Grove side. but a lot of that area, we wouldn't necessarily have to put a guardrail there. And some of those are actually part of the settlement anyway.
Yeah, I'm just concerned about that large number, and the totality of it coming out of that one unit
Yeah.
when there's, you know, again, I'm supportive of doing this. I just think we need to get that number down.
Yeah.
Because we've got other things to be doing there.
Yeah, no, I understand.
Okay.
So, but they're certainly creating problems on those roads that unit will be paying for in the future as well. So,
Right.
yeah. And again, if we can procure, use guardrail, then this goes down significantly.
And the question about how much is in the reserve, you're gonna get back. to
Yeah,
us
I
on
will
that?
get that,
Okay.
yeah.
All right.
I have the question about 180th. I believe you sent, there's someone suing us not to do that.
But that's just something that we did get something yesterday, and we're reviewing that.
So I believe this district attorney will be asking for a shade session, but we cannot delay in putting a guardrail in, because if we do, then there will be change orders, or it'll cost even more in the future. And the bigger problem is that they will be destroying brand new sidewalk and brand new landscaping and edge of road going in and out of there. And we gave them an avenue, no pun intended, to get a permit for most of those properties.
Through the chair. I will say my personal opinion is that the resolution that we just, in the direction we just gave to staff.
Yep.
That particular issue falls right under and doesn't require it coming to the board for further direction, because it's the same issue. That's
I
my
agree.
personal opinion. So.
Okay.
I do have one comment. I think maybe Mr. Boyd and I need to talk to see if there's any changes that need to be done to any of the water control plans. The water control plan for, if we're going to charge them for this.
What's coming out of R3? Not unit 4 for 180.
Well, you're thinking of unit 6.
Oh,
Yeah, because it's coming out of the fund reserve.
You can have a conversation. Sure.
Okay.
Well, I think we need to be able to look at that to make sure that there's no issues as a result of that resolution. I did not understand it was coming from a particular unit of development. And if that particular unit of development is going to bear that cost, then we need to look at it.
Through the chair. Can we just block off that one problem area for the moment? And then bring this back in October? I think we have all the information.
The southern portion, or?
Yeah, the portion,
62nd,
the
or-
portion where they're cutting through at Sycamore and 162nd.
Yep.
Isn't that where they're coming through there?
Mhm. South.
That's the biggest issue.
Closest to Okeechobee is where we're having, just north of Okeechobee in that section,
Right.
162nd.
and that's where
So
that
we can
pipe
do
was,
that.
right?
And the 180th, I thought we already had directed that as part of
Yeah.
the. we
Well,
had a-
we were just putting it on the record to be.
For the
Okay.
cost
that
and,
we're-
yeah.
Okay,
We're gonna.
but
be
so you
using
can
our
move forward
funds.
still on 180th without this being passed because it was already approved earlier. And then on 162nd, in Sycamore.
Yeah.
You can address the issue there. And bring it back in October.
I had a quick question on Sycamore. Isn't the majority of the north side of the road on the other side, isn't there a large retention pond within Westlake? Just
It
several
is.
feet?
But along what's happening is you're having people that are crossing there with dirt bikes and side by sides coming through Westlake, maybe not necessarily from Westlake only, but they're also coming from Loxahatchee Grove.
And that,
as
because
well.
I know there's a fence immediately kind of
Yeah.
through the woods. I
They've
mean,
been
does it?
cutting the
They've been
fences.
tearing it down on the Lox Grove.
And then
side.
the only question about the guardrail is, you know, we installed it along 140th prior to the whole Minto thing. But if you look, 140th by the school, sorry. You get towards the north end of 140th, closest to the school, where they've already built up, berm, and they've put their own fences in. I mean, is there any way to reuse that some of that guardrail in that section?
That's not our guardrail.
That's not.
That's
our
not ours at
guardrail.
all?
That's not the guardrail we did.
Okay.
No, that's.
Ours is
that
on the
was-
south of that, right?
Ours, the guardrail that we have is just that section by 43rd and 140th. And
Okay.
then we put a small section at, what's the other one? I think there's a little bit of guardrail near, 140th and 40th where the gate is,
Okay.
but it's a very small.
Yeah, because there's a
area.
guardrail
had to
and then they
block off.
bermed it and put a fence up, so it's like double fence. I didn't know if that was ours or
Yeah,
not.
they did that.
Yeah, that was not, that was, Seminole Improvement District that installed that guardrail.
But they left the opening.
Nice, yeah.
Yeah, that's being addressed.
We're addressing it.
Okay.
So I'll bring this back and I'll have the M2. Unless, and we'll, I think from the water control plant. We are not worried, but yeah.
Okay.
All right, then I'll just bring it back in October. So we
Okay.
don't need to do anything on that.
Sorry.
Okay.
No, you're fine. That's fine.
Okay, so moving on, oh, okay, let's stop and do public comment.
Go ahead. Mary Ellen Doherty, I pulled your card and I put the semi truck as a separate card for public comment, if you'd like to speak about that. Yes. Okay, and then the other one I have for when we're on that agenda item.
Good evening. I didn't come here to really speak about the semi trucks, but since we were talking about drainage and water and everything that's going on in our community. Most of the homes that are parking the semi trucks have pretty much paved the entire lot and have taken down all of the trees. So, you know, without grass and trees and in a rural community, this water is going to the neighbors' homes. And that is a problem. When I moved here, the trees, I left my trees, I just put where my house was going and I made it beautiful. But people decided we're gonna come in, we're gonna take down every single tree, whether you like it or not, it's my property. And that's where we are today here in this community. People just, there's no rules. I want to open up a trucking company, I'm gonna open a trucking company. I want to open up a taco stand on the corner, I'm opening up a taco stand. Tonight on the way here, someone's got a big barbecue truck right on their front lawn selling barbecue. Do they? I don't even know. What are we doing here? We have to come up with some solutions and some rules. Without rules, unfortunately, we have chaos. And frankly, when I drive around my community that I lived here for 26 years, I am appalled. I have a man down the street from me for 4 years. He has a backhoe on his front lawn with flat tires. The man 3 doors down from him has a city bus. I don't know how many tires a city bus has, but I think it's maybe, I don't know, 10 tires. I don't know what's on, but they're all flat. And if we all just decide to be, we are a junkyard. And the water problem, all the problems we have are problems that we have allowed to happen because we are not enforcing the rules. And I don't know what's going on with the trucking now, but I'm just not willing to call up on my neighbors every single day and be a policeman. I go to work, I work hard, but I don't get paid to be a policeman and have people mad at me all the time. But I also am furious when I come home here and find people moving more trucks into the community and haven't stopped or yielded to any of the problems that we have had. And I thought in July, we were gonna have some kind of sweep. I went down many times and spoke personally, took time off from work, and I just don't see anything happening. And I really hope that this committee would please be careful. We could be a beautiful community, but we're not. Definitely not. Thank you.
Thank you.
Thank
I'd
you.
just like to point out that the issues that you speak of are nothing of under our control. It's all the county. So these are things the county needs to address.
We are stuck. And
Right.
we've been stuck between the
Right.
county and Indian Trails.
Right.
I've been calling up for 26 years. And every time I call up, it's a block. So we're the only ones suffering.
And we're your voice, so we need to make it loud and clear. So thank you very much.
I'd just like to, I agree with you, but what you're seeing, I think there's one house that has that backhoe and a barbecue truck that actually is illegal. but everything on Orange Boulevard and, that area is county roads. And same thing on North
I'm
Lake.
not
They-
talking about the man
Okay.
on North Lake, just coming here, I don't know what road it came
Okay.
through.
It's 140th, it's 140th, what you're
Has a
talking about.
barbecue truck right on the front lawn, so.
Because county roads,
You know,
they get a
maybe-
county vendor permit, they can do what they want.
They don't even need a permit anymore on county roads. Yeah, I just went through this. They don't even
But
need a
you're
permit.
Right, you're
Yeah.
right. I've seen it and said, wow, I can't believe they just put their back front yard, a barbecue truck and selling barbecue.
The only time they need a permit is if it's on private property. They don't need a permit to be a road vendor on a county road.
Right, but if it's on private property.
They do. Then they do,
Yeah, so.
right? And there's
we have
rules to
beg the
follow then.
Question whether or not the food truck, village, is actually legal.
Well, on the corner of Orange and Coconut by my house, actually, I looked up
140th.
the roadside vendor permit.
140th
And you
and
can get a
Orange.
roadside vendor, but it says if it's in, within 1,000 feet of a residence, it can't. So,
All right, well, we'll have to look into that. That's all.
oh, I don't. wanna
Any
get rid of
other
that, but,
public comments?
There's, you don't want to read the email? or just-
Um,
It's just about the paving or the other milling.
do we need to read an email into the record, Mary, or can we just
Fine.
file it, receive it?
Well, if somebody emailed it, I'd like to hear it, so.
Okay, I'm fine with
Okay,
that.
Rather than receiving.
Okay.
All right, so this is from Jim Fayes. No address, let's see. I will not be able to make the meeting tonight, but I have these questions concerning the recent Millings lottery announcement. One, it states east or west road. Are you not considering north or south roads? Number two, it states quarter mile and half mile roads. Are you not considering a residential dirt road slightly more than half mile? I live on West Epson Drive between 168th Trail and Cheatham Hill Boulevard. I went to several meetings last year during the millings process, and I was told that Cheatham Hill, south of Okeechobee Boulevard, was not paved or milled prior because of opposition. There are only 5 residents on that stretch with a Cheatham Hill address. Although the road services at least 60 residents, all are in favor of submitting a petition, but want to know if it's even a possibility. We on Epson are going to submit a petition this year. Currently, this section of Cheatham Hill and 168th Trail run parallel, and neither are paved, both requiring frequent grading maintenance. Most residents in this section feel forgotten. Please consider paving the section of Cheatham Hill south of Okeechobee Boulevard. I will not be able to attend this meeting. Terry, the helpful operator at the office suggested I fill out this comment card online and I would receive a response.
Thank you, Chair.
Mhm.
So just, this has come up numerous times, and, this particular section is a section that is south of Okeechobee. And, there has been significant opposition from residents in that area, you know, going back to paving plans. So, but having said that, it is, I think, the only section that we have in the district that has such a long stretch that is not served by a paved road, and that's what he's stating. And I thought we had given direction previously to look at milling that section, south.
You know, it was discussed, but it was
we
never
never-
corrected.
Okay,
And just,
because of the length.
well, at that time, it was the length, and there was also still opposition from some of the homeowners there, but the board decided to do that as a test project or pilot project, doing 1/30th between Persimmon and 44th, basically.
Okay, so the other problem with that particular stretch is when you get to the end, there's not a proper stop sign. It kind of curves. There's a stop sign there, but then it curves, and there's like just 3 houses, and then it goes to the 168. So I don't know if we can look at that. The other thing, and it's really hot in here. But on the west side,
I dressed her.
I talked about this, that the trees are growing over into the road. And I don't know if some of that is like fox trails or deer runs responsibility. But when there's a storm, there's those Australian pines and then they get knocked down and it blocks the road. Yeah, anyway, and we don't have a sidewalk in that section at all. So I have heard these complaints since before I was on the board, but we still haven't come up with a solution for it. So I don't know if we can look at, something for that.
Okay. Anybody else?
Yeah, one more card. Lisa Johnson?
Hi, yes, my name is Lisa Johnson. I was here last month when the medical building gave the presentation and then they were directed if they wanted to go to ALA, which they did yet last night. Last night they did have some handouts. And I know you, Betty, especially spoke about the water retainage and I don't know, I don't remember at that meeting if they had anything laid out, but they did for this one. And it was a 22,000 square foot, 1-story building with parking and there's no water retainage whatsoever. And I asked them specifically, with the parking, with the whatever that's called, a setback, and the drainage needed, how big could your building be for 1-story? Because they did switch it to 1-story. And he didn't have the answer. But then when I got home, he had handed that to me and I didn't have a chance to look at it until today. It's wall-to-wall building. Now, when that goes on October 11th, that goes to planning and zoning. How do we address that with planning and zoning to say only 10% of our property should be a building or whatever? Because for every doctor office, there's got to be so many spaces. And when he left this room, as he was leaving, somebody asked him what he did, what his practice was. He said, I'm a GP, but then he mentioned that he was going to have OBGYNs, cardiac, which I understand we need all that stuff, and a dental office, but it was going to be big, but they pitched it as a medical, dental, and professional building. So they're not only using it as they pitch it as a husband and wife, but I just want to know how, and we're going to do that, at the planning and zoning so that this doesn't continue to happen, that we don't have the retainage that we need.
Thank you, Lisa. So just so you're aware, there's a DRO process with that Indian Trails has a seat at that table and our engineers address all of that at that time. Mr. Foy, I don't know if they've made the notes or comments available to you yet on that or not. I know they hadn't submitted anything when they were here yet, but they will. Fortunately, now we're included in that in advance of the DRO getting pushed through. We went through this with a couple of other properties where that was not available and it died right there. So that is something that we address on a professional staff level. So rest assured that has to be done one way or the other through the approval of legal and engineering. You're welcome.
Through the chair, Lisa, you said that they had a site plan? Because what I saw didn't have a site plan. It just had like drawings on a map. So it's
I talked to the engineer, he said they haven't figured out anything yet. For sure.
yeah, so based on what I've seen, this doesn't even have, oh, did you see this?
Whoops, there's. You said something about under.
Did you see that?
Yes, that one, excuse me, that was in, we had a meeting with them and yes, they essentially do have wall-to-wall parking. I mean, there's some landscaping around, but they have been informed that they have to meet our equal compensating storage. They've been informed that they need a special permit and it has not come up in a DRO comment as yet.
Okay.
So.
But
it will
know
be
that we're
covered.
paying attention to
They
that.
have to get a permit.
Right.
But this isn't just a DRO process. This is a land use change and a zoning change. So the reason why I recommended, well, one, they're supposed to, under the neighborhood plan, go to the Acreage Landowners Association. But the acreage landowners can object to the text amendments, the comprehensive text amendments, and also point out what the requirements are that were agreed to in the neighborhood plan that has not been amended. And that is that you cannot have commercial on anything less than 10 acres. And also that's why I reiterated the reason why we supported the text amendment for the overlay at Orange and Seminole Pratt was to actually prevent these kinds of things from happening. Now, unless the acreage landowners thinks that, maybe there should be some consideration at this particular corner, then I think, what they're proposing is not supported by the comprehensive plan or the neighborhood plan. And that's the position that the landowners need to take. So.
They misunderstood at the last meeting because they specifically asked last night if, actually they were asked how you guys felt about it and they said you supported this.
I don't recall us saying
We
we
didn't,
supported
we
it at
didn't
all.
even see the plan, so, okay, thank you very much. All right, there's no more cards. Do we
Through the
have
chair?
Dr. Delaney? Yes, ma'am.
I'm sorry, we got one more email. I thought it was gonna be in the red box. It was from Armando Hernandez. And
We're
basically,
checking now. Thank you, Scarlett.
you're welcome. If not, I got it where I can share it and.
Sorry. We found out. Thank you. We have it. So we have one more from Armando Hernandez. He says, good afternoon. I noticed that 3 new speed bumps were placed on Persimmon between Royal Palm and 140th Ave. I'm sure this was
Keep
due
it down,
to
Dennis.
drivers speeding up and down the road. I live between Mango and 110th Ave. There is a roundabout there which is meant to slow traffic, but unfortunately, after passing through the roundabout, it seems vehicles speed until they get to either Mango or 110th Avenue and slow down for those bumps. You can hear the engines revving as cars zoom by. There have been several times vehicles don't make the roundabout and wreck or overcompensate and take out a mailbox after scoring the roundabout. The big issue is the location kids are being dropped off by Palm Beach schools. Currently, the drop-off location in that area in Persimmon and Mango, the kids then have to walk in the same area cars are speeding in. Additionally, only one side of the road is paved, which is fine, but the kids either walk on the easement or have to cross the street. I'm hoping another speed bump can be placed between Mango and the roundabout to help control the speeding vehicles in the area. I thank you for your attention.
Through the chair.
Mhm.
Because this has become another social media discussion, I now have a new nickname. I have Betty Bump as a nickname. So it's Betty Gay, Betty Bout, and now Betty Bumps. So for the record. For the record, I want to question staff on a couple things. Did I direct you to put those bumps there? Did I personally direct you?
No, ma'am.
Okay. Did this board plan for bumps to be added on that road?
Absolutely.
Did we do it through a mobility plan?
Yes, we did.
That-
That through the CapTech engineering based on the mobility plan. Those
That-
locations were chosen and the type of speed bump were chosen as well.
Are they done according to engineered plans?
Yes, they are.
Okay. And those particular speed bumps are temporary, right?
Yes, they can be.
And they are designed to allow fire rescue and emergency rescue vehicles to essentially straddle the opening, correct?
That is correct.
Okay. And have we confirmed, because I know when we did the first set on 140th years ago, people didn't like them then either, by the way, but we did some modifications because it turned out that PBSO fire rescue trucks were designed a little differently. So we made some modifications. Did we install the ones on Persimmon with the modifications that we determined met PBSO's fire rescue?
They are the same manufacturer, the same exact bump. We met with fire rescue. We had the chief out there. They did a couple runs and this was the best option for them so they could straddle them. So once they approved that design, that's what we're using throughout the district.
Okay, and lastly, for Burgess, do we have the money to put asphalt speed tables throughout the district in every single place that our engineers have determined we need to be able to address the concerns in the district?
No,
And-
we did one phase.
We
the
did one
first
phase
of
through the R3.
Asphalt traffic calming speed tables.
Right.
And then for the operating budget, which is what people are seeing out there, we're using what Mr. Robinson was talking about, either speed tables that go all the way across that are pre-manufactured with rubber, basically hard rubber, and then the smaller speed cushions for fire rescue, and both of those are compliant.
Okay,
And
and how much are the speed tables, the asphalt speed tables?
There are $18,500 a piece.
And the rubber ones are reusable when we remove them, but how much are they?
I don't
like
have the
they're-
exact dollar amount, but there are only
about
several.
8,000.
Okay.
Yeah.
And we
7,000
can
to
reuse them
8,000.
when we remove them, unlike an asphalt speed table, we have to grind it down and that's it. Okay.
Correct.
So it was our intention when we did those temporary ones to address a problem that residents have been complaining about and some concerns that we have according to our mobility plan. And it is not being done to get at anybody. It was always in the plan. It was done in 2019. We had public hearings and we don't have the money to address everybody's concerns, but we're trying our very best. And so I think it would be the intention that when we have sufficient funds to replace those with permanent ones, when we determined that that's what we're going to keep that road as, because we may want to make other modifications to the road in the future. Because there were other recommendations in the mobility plan in terms of how to deal with it, correct? Okay,
That's correct.
and just lastly, one last thing for the record. When we go through a water control plan and we have the public meetings, those public meetings are notified as per statute, correct, Mary?
For the water control.
Mhm.
Absolutely.
And for the R3, as I recall, we did that 3 times for the R3.
We had quite a few public hearings.
But we had 3 certified mailings for the R3. Is that correct?
Yeah.
Yes.
Yes.
All right. And then for the mobility plan, we also had
We
public
amended-
notices.
We amended the plan to include the mobility, the R3 plan to include the mobility.
Okay. All right. So what my point is that we can't be responsible for what residents pay attention to or don't. When we send a certified letter, we send out notifications, we put up signs throughout the district, we stand in the middle of Seminole Pratt, people are still going to say they did not know. Okay. But the one thing I do want to say about Persimmon is that we had a lawsuit. Okay. And despite all of that, there is going to be a connection at 140th and 60th. And Patty, you may not like me saying this, but this is really important. Despite all of the lawsuit and everything else, that traffic is going to be there. And we need, as a board, to figure out what we're going to do to protect that area, or there's going to be a tsunami of traffic. And if you think you have a problem with traffic on those roads now, you haven't seen anything yet. So, and by the way, part of what the attorney said earlier is that Minto is negotiating, and I brought this up a couple months ago, they were negotiating with the county, being pushed by our county commissioner to complete between Seminole Pratt and 140th and to not do a damn thing to 60th Street. And if you think that's okay, well, have at it. So there you go. Thank you. I appreciate it.
Anything else, Ms. Bumps, argue?
Okay. Any more? public
That's it.
study? Okay, we're
We're
done
done.
with public comment. Okay. Dr. Delaney is online. Mr. Henson? Okay.
No, that was public comment.
Public comment.
Yep. Okay, guys, please keep it down.
Yep.
7.2, this.
Go ahead.
Oh, okay. This is for the board to consider an interlocal agreement, an ILA, with the Treasure Coast Regional Planning Council, TCRPC, for strategic planning services. Mr. Henson?
Yes, so I believe Ms. Akamundo brought this up several months ago about approaching staff to find a way to do a strategic planning session. And I had some discussions with Ms. Delaney or Dr. Delaney and Thomas Lanahan with the Treasure Coast, because ironically, good segue from earlier, they're the ones that helped us with mobility plan and another plan that that was worked on a couple years ago. So thought it was best because they understand the district, they know the players, they've had meetings, numerous workshops, meetings here. So I asked them to bring forward a proposal for this board to consider.
Through the chair. We've been discussing strategic planning for years. So my question is this paying somebody else to do a strategic plan, or is this involving the board doing a strategic plan? And this is a facilitation,
This is actually bringing in somebody that is not staff
right?
to facilitate not just with the board, but even with the public in a couple
Okay.
different areas. But it's also to facilitate with staff as well, you know, whatever your goals are, how we logistically can do those. But Dr. Delaney can probably give you better explanation on how she and her team will approach this. But yeah, this is actually for the board to develop a vision, mission, and what your goals are over the next however many years.
Okay. That I support, because in the past, we've been told, oh, we can't do that. And it's going to be a staff thing. And I think it has to be the board and it has to be the community being involved. So,
Absolutely, and that's the
yeah.
plan. Dr. Delaney?
Hey, good, so good evening and nice to reconnect with you at ITAD. Thanks for the opportunity to talk with the board about the idea of a strategic plan. Just to add to Betty Bump's point, so the Planning Council is available to work with local governments and agencies like yours to take boards and the public through strategic planning conversations. It's kind of a core part of what we do as a resource agency for the region. And so I think there's a scope letter that's attached to an interlocal agreement that Mr. Palin developed. And it details the process, as Burgess mentioned, outreach meetings with you as individual board members and with staff to kind of understand the issues, and then facilitated discussions with you and the public to identify the major issues, and then stitch those together into a strategic plan document. There's a lot that I've been in your meeting since it began tonight, and there are at least a half a dozen issues that are really big issues that sound like they would be benefited by some kind of like out of the public hearing process discussion about what do you want to do about the roadway network and how should it be defined, and what should be the relationships be with the folks that are around you, and what should the priorities be as you carry forward. And so this process is designed to do that, kind of lay out all of those issues, understand what the board's priorities are and the public's priorities are, and then piece together a strategic plan for you to implement over time.
Thank you, Doctor. And I think it's really critical because the community is changing right now at such a rapid pace. And we need to have this plan, and we need to know where we're going in the next few years, the next 5 years, the next 10 years, and plan now instead of playing catch up. We've been doing a lot of that, but now, we're up against all new animals. So I'm grateful to have you on board, and I look forward to this process because, even though we're a government, we're still a business, right? And we have to think ahead and we have to think to the future and where we're going and what our surroundings are changing us. And how are we going to deal with that? And how are we going to address that? And your relationship with this board, with the previous board, with the community, I think is imperative. And having these conversations, and how we can, we're not going to be able to change it, but how can we adapt to it properly where it's beneficial for everyone, something everybody can live with. And, how are we going to face the challenges that are coming up very rapidly upon us? So I thank you very much for all of your efforts and your time. We really appreciate it. And if the board has any questions of Dr. Delaney at this time, no, then I think we can call the question, and then bring up any public comment. Do we have any cards
We
for
have
this
to have a
item?
motion to call the
Yeah,
question, so I'll
okay.
make the motion.
Okay.
I'll second it.
Kim, you're looking great.
Thank you. So I need to get out to ITID and walk around some more. That's what it feels like.
Yes, you do.
You second, Keith?
Yes.
Okay. All right, we have a motion to approve the ILA between ITID and Treasure Coast Regional Planning Council for strategic planning services. Scarlett, and Ms. Argue made the motion, Mr. Giordano second. You got that?
I did, thank you.
We do not have public comment on this item, so we can call the question. All in favor?
I'm
Aye.
sorry, because nobody submitted.
Right, yeah, there is no card for it. Oh, absolutely.
Chairman, Dr. Delaney, if you have anything, I'll see you Friday.
Very good. So I look forward to it. And and can I just compliment the board on how great it is to have representatives that attend the planning council meetings? So I know it's a hike to get back and forth, but it's really helpful. So because you bring a very different perspective into the conversation, and I think it's really valuable. I know the board members really appreciate it, and we as staff do. So so thank you for investing that time in those regional conversations, because I think it makes for a stronger region.
And I agree, and it's nice to be included because all too often we're forgotten about because we're not a municipality. So us being there and participating is very much appreciated by the board and the residents.
Yeah, the last
So,
time they even gave
thank
me a
you.
nameplate for a change.
See that? You're moving up in the world. Thanks, Doc. We appreciate that. Thank you very much, and we'll be talking soon. I look forward to it.
Thank you so much. Have a great night.
You too. Thank you. Okay. All right, moving on. I'm sorry. Oh. Item number 8, other governmental updates, Mr. Hanson.
From a staff perspective, I don't really have anything to
Okay.
submit tonight, and I don't believe there's anything before the DRO.
Okay, beautiful. All right, we already
Not-
did public comment.
Not sure if any of the supervisors that have any updates.
Well, we know that Wellington approved the commercial zoning along Seminole Pratt from Southern to Harlena. The west side was already approved commercial by the county, so now the east side is as well, and we're gonna have some high density housing behind that. It's part of the process, but
It was the first hearing.
it was right, but it is going to be approved, so it is.
There is still a second hearing. and
Yeah.
None of our residents, well, except for 2, I think, showed up.
Right.
So if people want to chime in, they have an opportunity to do so.
Well, they're going by the residents that live there and what they want, clearly. So if anybody does want to go, I would suggest that they do.
I'm
we'll
not sure.
have to
what the
look
ne-
up.
I think it's October 14th or
It's
somewhere around
yeah,
there. It's like a Tuesday.
yeah, it's a Tuesday. You could check the Wellington website. All the information is on there.
Wellington Town Council.
Mhm. Anybody else? Okay. Looking it up.
Can we,
Break,
yeah,
10?
the only thing I was thinking, so you got people here for this, the permits.
Mhm.
Um. So that's what we're going on to, right?
Mhm.
So,
There's really nothing after that. Couple
So-
presentations, but yeah. So break or blow through it.
I need a break. I'm like.
Do you mind? 5 minutes? 5 minutes? Okay, do 5? Okay, we're gonna take a break for recess for 5 minutes.
watching.
Okay, on to our next agenda item. Facilities, Parks and Recreation. The approval of a facility use permit for the Academy of Dance and Acrobatics. Mr. Lawrence, do you have a?
Yes, we received this permit from the Academy of Dance and Acrobatics. They would like to host an event on December 14th from 11 a.m. to 6 p.m. This is the group that would normally be a part of the Frontier event. Normally, it's only about an hour or two that they would actually do a performance at the amphitheater, and then they join the district's event at that point. They have requested to extend their event a little bit longer, which is why it's here tonight, so that the board can kind of consider it. Plus, it would be at South Expansion. I do have a meeting with them on Tuesday to go over the park restrictions, that they are aware of what's going on.
And this will all be confined to the area that's unrestricted.
Correct. It would be the amphitheater and just the park,
Okay.
the part that the district has authorization.
Excellent. Does anybody have any questions or comments?
I make
Nothing.
a motion to approve.
A second.
Any public comment on this?
No.
Okay. All right, and we'll call the question. Scarlett, do you have the motion?
Yes, I do.
Okay, all in favor?
Aye.
Okay, see that it passes.
But just, it's
I-
good to call even the public here to see if there's any public. comment.
We had no cards, so. Okay. All right. See that it passes unanimously 5-0. Next item. Consider the Acreage Landowners Association Halloween on Citrus Grove event. Mr. Hanson or Mr. Lawrence, who's going to present?
So just quickly while
Through the
he's
chair, sorry, before you start, can I just say, this is Halloween in Citrus Grove Park,
yeah, well,
not
this,
on Citrus Grove.
yeah, this is actually the old permit,
Okay.
so we have not. So that's what I was gonna explain real
Okay.
quick while he was setting up. So through the chair, the ALA has withdrawn their original permit that we had on here. And they, over the past, 2 days, basically since Monday, they've worked with Mr. Lawrence along with legal, Miss Heiser, and then Aegis, and we do have a representative who we'll introduce here in a second from Aegis to answer any questions about not really the old permit, but the new permit, if there's any concerns or anything like that. So there are some differences here. So the ALA is not submitting as a service provider. It will be an independent agreement. And there's some other changes that, as Ms. Argy just addressed, that they're not going to have anything to do with what goes on outside of the Citrus Grove Park. But with that, I don't want to take away from Parks and Recreation. Go ahead, Mr. Lawrence.
So some of the details of what they have inside their permit is the permit's requesting from 3 o'clock to 10 o'clock. The event itself would be from 5 to 9. They are requesting a food truck, specifically a taco truck if available. One bounce house, between 4 and 6 PBSO officers. Honestly, that should be a recommendation from PBSO on what they would consider to be out there. From our experience from past events there, it averages about 500 people inside the park. We know that because of the popcorn that we turned out. And they're agreeing to indemnify the district, and there is a separate agreement for that. The district's requests that haven't been added to this is we're going to request that there's no alcohol inside the park. No additional cars can be allowed inside the park once the event starts. Parking passes specifically for any of the vehicles inside the park. Obviously, the new independent agreement and hold harmless for the district. Speaking with Aegis, they have requested an event safety manual. I was mentioning it the other day as well, some kind of site plan to kind of show how they're going to keep that event safe and who would be inside of it so that we can make sure that we have the proper insurance and licenses from like the food truck or whoever's supposed to be there. Additional restroom facilities, highly recommended. It'd be something that would need to be out there. We would usually have 3 with an ADA one, so there'd be 4 total. with extra wash stations. And then, on top of that, the district, there's a motion that would have to come in. Obviously, the park is currently closed, so we'd have to do something with the closure that was already in place. So what the district is asking for at this point is that we continue with the one additional officer, because the event on Citrus Grove actually continues on past 10 o'clock. So what we'd like to do is actually have that officer start at 10 when their event ends, and then go on till about 2 a.m. So assuming everything quiets down by 12, we would then take the officer from 12 to 2 and have them kind of patrol the district and make sure everything's quiet.
Specifically to patrol other district parks. But
Correct.
that would be, the district would pay for that, just to be clear. And so,
Through the chair, I think also there was a fee waiver on that.
Correct. There's
And,
a fee waiver as well.
With respect to the additional washroom we have the trailer at, Hopeful. Can we move that over there so that they're not having to do, because I mean,
Not
the
easy.
6 police officers is $88 an hour.
It's not an easy item to move. It needs water hookups and everything else. And I'm not sure the condition of the trailer. The trailer's been sitting there for a long time and it's rusted. I wouldn't advise it personally. But
well, if the board would like, we can look at it. I don't know what the condition of it for mobility is.
Because that was the whole point of that trailer, was so that we could move it for events, so.
Do we own that trailer? Or is that-
We do.
Yeah.
We pay to have it emptied and cleaned all the time.
no, that's basically
all
it
you-
as far as big changes. If you guys would like to know some of the challenges that we've faced inside that park, just so you guys have reference of what
Please.
to kind of expect. 5 to 7, the event's beautiful. It's perfect for the kids. As soon as you start reaching the hours at 8, 8:30, 9 o'clock, it gets hectic. That's where you get the teens coming in. That's where you get potential fights. The first year I did this 3 years ago, we had 4 officers with 10 staff. The past years, we've been bumping it up to 6. We've had 6 PBSO officers with our 10 staff, and we have to break up fights and things like that. So there is going to be some issues, including the kids with the bikes, doing the wheelies and everything else. Expect that from 8 to 10. I
I
do
know
have,
last year there was some underage drinking that PBSO had to escort the
correct,
kids out. They were starting fights.
correct. Outside of that, and not to get into detail with anything else, but there is another concern that I was thinking about this morning or last night. Avocado is actually kind of an exposed area. They have tents set up there, and people going inside the park have the ability to go outside, and you have this road where cars can be flying down outside of the park that's not blocked off. So that may be something to look at, either for this or even in the future. Maybe strategically placing PBSO blocking off that section around Avocado on the east side and Citrus Grove. But that could just be done with officers.
Additional officers. Okay, well, I'd like to hear from our insurance gentleman, so it's been patiently waiting.
Well, appreciate you guys inviting me and the opportunity to speak to the board. I met most of you. My name is Andy Jimenez. I'm the Executive Vice President for Aegis Insurance and Risk Advisors. And I am the Program Administrator for Florida Insurance Alliance, FIA. Most of you are familiar with FIA, but for those that are not, FIA is the governmental self-insurance trust that provides the property casualty insurance for the district. We're more than just a carrier. We see ourselves as an extension of the district's risk management department, and we work closely with the staff to share our resources and their expertise when it comes to increasing the safety of the employees, as well as helping the district mitigate their general liability exposures, public officials, employment practices, and property exposures. We were brought into the Halloween event conversation a few weeks ago, and I apologize because I was not aware of the second permit. So a couple of issues that we looked at to kind of help assess what the potential exposure the district may have was obviously looking at the history of the event. and getting the feedback from those that are most familiar with that exposure and what could potentially happen, which is the staff, right? The staff share some legitimate concerns regarding their ability to ensure that the event can be done in a safe way and that they have the resources to ensure the health and safety of not just the visitors, the residents, but also of staff, right? And then we looked at other models regarding particularly the contractual relationship that the district had with the ALA. They had a service provider agreement. However, in the first draft that I saw, it was an ALA event, but a lot of the burden and the risk was going to be taken on by the district. Also, the service provider agreement requires the ALA to provide a operational handbook. In a handbook would outline basically the safety plan, the crowd management, the staffing, the volunteer management, vendor management, and that hadn't been provided, nor do I think it was originally attached to the first permit that was filed, right? So we not obviously it's not our role to tell the district what they should or should not do. It's our role to help them and work with them to mitigate the exposure, and more importantly, to ensure that the health and safety again of the residents and staff, right? Would you just describe? I mean, it seems like to check some of the boxes of the recommendations that we had that should be taken, that the district should consider to transfer the risk over from the district to the party who's going to have control of the event, which it appears going to be the ALA. Some of the things that we looked at was regarding, the volunteers, right? Does the ALA or the district have the resources and the staff to be able to maintain control and monitor the event and enforce the rules? If you have a district volunteer, that district volunteer could be an agent of the district. So any claims arising out of the negligence of this volunteer could fall on the district. Also, under Chapter 440, the workers' compensation statute, a district volunteer for the purposes of workers' compensation is a employee of the district. So any sort of injury that a district volunteer sustains during this event would fall under the district workers' compensation policy. And if you have a significant injury, you could potentially experience, your experience mod and workers' compensation go up, which you could be paying for that for the next 2 or 3 years. So it does have a direct impact on the district financially, right?
And may I ask, when you say a district volunteer, who exactly, does that encompass?
Well, that's a good question. So we wanted to make sure that it was clear whether it's an ALA volunteer. In other words, are they provided, the guidance and are they signing up on what are their duties as the volunteer, what they can and cannot do, and basically who is supervising them? Or are they a district volunteer that are working on the behalf of the district or under the supervision of district staff or reporting directly to the board, right? So basically, who is telling them what to do, right? Who's, setting the guidelines as to what they're supposed to do as a volunteer, what time does their time start and end? And, because if they start deviating outside of what, they were assigned to do as volunteers, then, the district's no longer in the hook because they are now kind of went rogue and doing something on their own. Right?
Through the chair. Now, that scenario that you're talking about relates to the service provider agreement arrangement. It does not apply to the district having a permit that has been issued independent of that, correct?
Yes, but if the permit is issued to the ALA, there's still a contract in place between the ALA. I mean, because if the permit is being pulled by the ALA as the service provider of the district.
Not as the service provider.
So
It's
just strictly
independent from that, yes.
Yeah, so independent, yes. So then you can have what is being proposed, which is an independent, basically like a use agreement or a rental agreement. If I were to go down the street and rent the church for a baptism, right? I would be in control of that facility. I would agree to indemnify the church for any claims arising out of my use of that facility. And I would probably be required to add the church in addition insured under my policies. If something were to happen during that event, the church gets pulled into it because they own the building, then my insurance policy will step in, provide a defense for myself as well as for the church.
Good Chair. I have another question, for Kenny, because this did not come up in the discussion that I'm aware of regarding parking in the park.
Mhm.
So on the one hand, we say we have to have ADA accessible, restrooms, but in the next breath, we say we can't have parking in the park, which
No,
the whole
No.
point of this is that
It
you
is.
have a place for ADA
yes,
parking and you have parents who are coming with little children and you want to give them a place to park. So I'm a little confused about that.
So the parking shuts down once the event starts because from our experience, there's too many people walking through that parking lot after that event starts. And you've got volunteers, PBSO doing different things. So once that event starts at 5, anybody that wants to park there, they're already gonna be parked there and they'll leave, but we can't have this ongoing.
So if you have somebody that needs, you know, an accessible parking space, where are you supposed to tell them to park?
I mean, to this date, we haven't had that issue and we've basically had that park each time we do a permit closed from like noon till 10. And we do that on purpose so that we don't have too much traffic in there because we have staff setting up all day. We use it for PBSO so that they have a headquarters to kind of base themselves out of with emergency vehicles. And the last thing we're trying to do is have a lot of traffic drawn into that park for that reason, so that we can guarantee that we have places to park.
Because we're also concerned because if PBFR fire rescue has to respond, that area in general is you've been there, so it's very tight. And they may have to set up or park in there and maneuver through there. And one of the concerns that we have is if you have people continuously going in and out and parking. Well, I know so-and-so, and they said I can park behind them. And now if there's not a volunteer or a PBSO person there to say, hey, you can't park there, they will park there. And you need to have by fire code anyway, you need to have an open, lane of traffic. So that's part of the reason. So, and if something does come up, then and there's available ADA parking space, then, I guess arrangements can be made because it would be discriminatory, but for the most part, you don't.
That's my concern.
Yeah.
We haven't, like I said, we haven't had that issue. I have had to leave in the middle of the event to go get stuff from Publix to stock us back up. And it is very difficult entering and exiting that park. A lot of the people.
That roadway every year though, so it's no different than what we've been doing.
Not that particular
No,
road.
for that event, but we've shut down those 5 blocks or 4 blocks of roadway for
Yep.
years.
Not on the avocado side though, where we're talking about where the parking lot is.
Yeah, specifically speaking to, I'm sorry, just for the record, it's Captain Turner we're speaking with PBSO, but yes. We're specifically talking about the parking lot where the ingress egress is off of Avocado,
Yeah.
just north of Citrus Grove Boulevard.
And you don't block that portion off.
No, I'm just saying, you're talking for whatever specific parking, but we've done that. I'm saying on the event on Citrus Grove every year, we shut down those 4 blocks. It doesn't matter if a car wants to go in for any reason, we don't let them in. So we have to just work with Berkeley Road to set us up some kind of overflow parking area to do stuff like that. But once we shut the road down, we can't let anybody else in because it just gets too dangerous at that point. Even people
crowded.
on
There's too
bikes.
much
they're-
pedestrian
Coming from the north, though. They
I
come
thought-
from the north of Avocado,
I'm
My
talking
understanding in terms of what's been closed down has only been,
east and west.
east and west on Citrus Grove between,
No, we've shut down.
Avocado
we've shut
and
down
140.
Outbank entrances, we shut down north-south roadways, we have people at each location to assist in getting cars through north-south, but we don't let them get back on that roadway or park anywhere near those. We have people stationed at every one of those intersections that will try to let people get through, but we've shut down complete access from the Outbanks and everything else over the last few years.
but people can travel north and south on Avocado and 140,
Right,
correct?
we'll stack them up there and then let them go through in a controlled manner with a traffic control person at each point.
Okay,
Which is the concern that I was mentioning earlier. I was kind of thinking of a scenario, and I don't want to go into a lot of detail, but say a parent dropped off their child to go to the park and they cross Avocado and it's not blocked off. they could potentially get hit. It's dark, it's a dangerous area. That is a section that you might want to close off because it is indirectly a part of that event because people are set up on the outside of the event on the district swale. It's something you may want to
We have
consider.
No authority, just to be clear, we have no authority to shut down roads or control roads.
And that's
So
not
we
part
cannot
of
even
this
discuss it.
permit.
Yeah,
The permit that the ALA is requesting is for an event inside the park. What PBSO requests to do outside the park to deal with the organic neighborhood event is independent from what the ALA is proposing.
I agree. And that's what I was
But-
suggesting is that the conversation would happen with Turner and Bert about how they strategically.
But I
place.
would
We
like
usually
to
have
talk with you guys about how do we handle people who do need wheelchair accessibility or can't walk very far. Because I do think that that is a concern when you're hosting an event, especially when the whole purpose of the park event by the ALA is to provide a safe place for small children. And sometimes that's grandparents taking out their children. So, and they don't have to walk very far when they go in the park. It's just, you know, so that's the only thing that, and the other thing is that, they have small children. So, you know, anyway, that's all.
Yes.
We
so
have in the past let parking in the park.
Not once the
When-
event starts.
When I was
We
there,
have said
Not
in the
since
past,
happened.
we have.
when I was there last year, we had staff.
Before.
Guys, let me talk here for a second. So basically, what I would suggest, and we'll put it in the permit if the board wants to approve it with this in it, is that ALA is responsible for having somebody at that gate. If somebody and there's available ADA parking, then they can park in there, but you cannot just let people go in and out of there because it will become a circus. And then it will interfere.
And I agree
you.
with
Yeah.
that. I'm just saying not to have anything is a problem.
But if they want ADA parking, they either have it on their license plate or they have a placard. So that's the easiest way to address it.
And through the chair. So I haven't seen the new permit, but who, is it ALA who's pulling the permit?
It's up on the screen. You should know.
So this is the current one.
Correct.
So question. They have an SPA with us, but they can open or they can have an event and it winds up not being,
They can do it if it's
Affiliated.
not, if it's
It's
not
part of
claiming
this.
under the special permit.
okay, so it's not gonna fall
Provided.
under, they're just doing it on their own.
There's, that's my understanding.
Okay. Sorry.
Go ahead, no, sorry.
You mentioned coverage, insurance coverage. What is your recommendation to make sure that they have insurance coverage?
There'll be insurance, I imagine there'll be insurance requirements in that agreement. I mean, there's insurance requirements now in these service provider agreement. What it doesn't have is a requirement, there's no indemnification language in favor of the district. I don't have it, I guess I do have it in front of me.
I did forward that to you.
There's a draft agreement.
I have
No,
one.
Yeah.
No,
Okay.
the insurance with the loss payable to Indian Trail.
Yep, we
was
do have
part of it.
the insurance, right?
Yeah, so I mean, the limits that are currently outlined in that agreement, in the service provider agreement, which I assume is going to be the same policy, that I don't think they're going to pull another policy or special events policy, unless there are other exposures that would be excluded under the ALA's policy. For instance, if there's alcohol, right? Also have to double check whether there is sexual abuse and molestation coverage in their existing policy. I believe that there is, but I would need to double check the ALA's policy. But the limits of liability, keep in mind that the ALA, unlike the district, does not enjoy civil immunity protection. So any claims against the ALA wouldn't be subject to the TOR caps, but the district would be. Also, I'm assuming that agreement would include the district as an additional insured on a primary non-contributory basis. So what happened there is that if there is an incident that occurs out of the ALA's use of this park, and the district asks the owner is going to be named defendant, the ALA would then provide a defense and indemnify the district for any claims being made against them, right? And on top of that, you also have the district's policy, to provide additional coverage, because the ALA is the primary carrier that would, their carrier will be the primary carrier to provide coverage. does not mean that that coverage is excluded under the district's policy. So for whatever reason, there's an issue, a coverage issue, or, there's a limits issue, the district's policy is going to be there, just in case something falls through the cracks.
So there's really no way to separate the district is what you're saying, because if they don't have enough insurance, then they're gonna come to the district for
That's
our
the purpose
insurance.
that we
So,
On a premises liability claim, it is the district's part. They still have a non-delegable duty to maintain it. What's happening here is that you're transferring the risk through that contract to the entity that is using it, and it's going to have control of it. So, if you have, let's say somebody trips over a cable that's powering one of the bathrooms or light or something like that. It occurred on a district park. So, they'll file a claim against the district, and they'll file a claim against the ALA. We'll find who's the person or the entity responsible for the placing of that cable. Whether there was a duty to warn the residents or the visitors coming in to warn or restrict access to the area where there's a trip hazard. The district has, in my opinion, in that scenario, no liability, but because it occurred on district property, they will be named in the lawsuit. And that's why it's crucial to have them, the identification language, as well as the requirement for them to be named as an additional insured. So the district can then turn around and say, hey, we're being brought into this lawsuit because of your negligence. We have no control over that event, and you agreed to identify us and take out a defense for us. You've got to handle this claim on our behalf.
but that's not gonna stop somebody from suing the district if they so choose
It's
to.
not going to stop, no. And honestly,
Including, now, does that include the district as a whole? Does that include staff? Does that include the board?
well, the staff should not be named individually. They're employees of a public entity. And you can speak more to this, but there's a statute that prevents a plaintiff from naming staff unless it's something outside the scope of the duties of their employment, right? So they do something on purpose or commit a crime or do something intentional outside of what they're supposed to be doing as an employee of the district. They could be named and there could be a personal financial exposure for them. But if it's something that's done as an employee, it would fall under the appropriate party to go after or to name as a defendant would be the district. Right? The individual board members. I mean, they can always name you, but I think it would be pretty successful in removing you because the appropriate party would have been the district.
And, okay, so let's just say then staff or the board is named in a lawsuit. Who's responsible for those legal fees?
Well, it depends on the claim. Like, what are they being, is you could be named in a lawsuit and not and the accounts against you may not necessarily be related to the event at the park.
Well,
Right.
So
so
when you're saying, I'm sorry.
that's okay. That's okay. Go ahead.
Are you saying, so let's say something happens on Citrus Grove where the kids are trick or treating and an accident happens there, they could pull us into that? Is that what you're?
They could definitely gonna pull the district, and that's the party that they should be pursuing would be the district. They can name anyone that they want in the initial lawsuit, right? But eventually, they will be able to remove those parties that have nothing to do with the lawsuit, and they'll pursue the claim against the district.
Okay, this is a acreage landowners event. They do have their service provider agreement with us. They do have their own insurance. Disney doesn't have people sign off. Can we have our lawyers put a sign up that says this is enter at your own risk to indemnify us? Also, if someone gets hurt on Citrus Grove, it's gonna be on technically the people's property. They have liability insurance, so we shouldn't be brought into that. They would have to sue the homeowner where they got hurt.
If it occurred on a homeowner's property,
Well, remember, they own the road, but we have the easement to the road.
Yes, but they own the road, so they're responsible. So if
Okay,
it gets hurt,
Well,
that's
maybe not.
liability.
Let's find out.
yeah, well, you have to kind of walk me through that scenario. I apologize. So who owns the road? The homeowners own the road? The ALA owns the road?
No,
No.
homeowners that own the home.
They own the road.
In the middle of the road.
It's an
The
easement,
landowners own to the middle of the road.
But it's an easement that the
It's
district.
an easement.
Right.
Right.
Which the district has.
Right.
The district.
So who's responsible for the maintenance?
The district.
Okay, so that's where the district gets brought in, because if you're responsible for the maintenance and there was a failure to maintain, or there was an obvious, hazard.
Karen, we do have attorneys and they did provide their legal opinion. I'm sorry you don't agree with it, but really. Okay.
Go ahead, please.
So, anyone has ownership or maintenance responsibilities. Basically the question that you want to ask when there's a claim is like, were there any duties breached? Right? In this case, if somebody tripped and fell over a missing manhole cover, is the example that we always use in insurance. Well, who's responsible for inspecting and maintaining the manhole cover? In this case, even though the district does not own the roads, if they are responsible for maintaining it, then they're gonna have a liability exposure for their failure to maintain.
I don't think that that's the type of exposure we're gonna see, as far as maintenance. Let's just say somebody's drinking and they're driving a four-wheeler down the road and they hit a kid. Because I know that was a concern with PVSO last year. So what then?
Well, so there's a couple of ways. I mean, you can argue that the district allowed an event. And by the way, we're just throwing scenarios here, hypotheticals, knowing that they didn't have the resources to properly, based on the previous events that they had in the past, they didn't have the resources to ensure that the event was going to be safe. Or they didn't have the right amount of sheriff deputies on site. Or they didn't really have a crowd control plan. So plaintiff attorneys get very creative and you're gonna start digging and trying to find, trying to bring as many parties into the lawsuit as possible. And obviously, anytime you have something occur on your property, whether it's being rented to somebody else, or you have a duty to maintain, if you're in any way related to the decisions that led up to that incident, you're gonna be brought in.
Through the chair. So even by allowing this permit, that would kind of leave us open for that?
Any permit.
Any activity that any district operation is gonna have some risk to it, that's why we try to do what we can to mitigate that risk. There's some risk that you have to eliminate and not take on. There's some risk that you insure for, right? In this case, you have a combination of risk transfer by having the contract in place with the ALA, outlining what they're responsible for, what the district is not responsible for. And making sure that they have the appropriate insurance in place to provide a defense and identify the district. And on top of that, you're gonna have some exposures because now you have increased traffic through the district roads going to this ALA event. If something happens 2 blocks from this event and because the district, let's say, failed to notice, I don't know if they're responsible for the stop signs, traffic control, but let's say for the purposes of this hypothetical, let's say that they are, right? Well, that increased traffic into the district was due to this event, but the district will still be responsible for that. Right.
Sure.
No, Keith is next.
I think we're trying to, what's the terminology? We're trying to look for things that might happen. I know as an insurance agent, that's what you and lawyers both do. But I grew up in New Orleans. They have what's called Mardi Gras parades. I've never seen the city get sued because someone got hurt on a parade route. They always sued the crew. So going back to this, if someone got hurt, they would be suing the ALA, not the district.
Well, I can tell you from my experience, and I oversee all the claims for 1,200 local governmental entities, that they're going to sue everyone that's in any way involved. And they do have the right, and in the owner, in the case of I'm not familiar with Louisiana claims, but I can tell you that anything that occurred on district property, there will be a premise liability claim made against the district, right? Regardless of who, and I can tell you, there's a lot of, from the outside, you may think of a lot of the scenarios, what's the likelihood? But my inbox every single morning is filled with those examples that you don't think would have ever happened. some of them occurred in this district. You know, we have shootings, we have drownings, and every day you see the things that no one thought would happen. And, the arguments do, that's what insurance is for. You have to take on some risk. We can't bubble grab everything. But you have to be, take common sense decisions. And I particularly, and I really enjoy working with this district because they take, the staff takes their job very seriously. Not just on the liability side to ensure the safety of the residents, but of the employees as well. And I think they have some legitimate concerns about the district's involvement in this event, based on some of the things that I heard that happened just last year.
All right. I think it's really important to understand and recognize that Citrus Grove Halloween is an organic event that the district does not control, has never controlled, has never organized, has never been responsible for. The district's part, at my urging, every single year has been, there are concerns about the safety of this organic event that we need to make safe. We need to help be a part of the solution. The residents want us to help be a part of the solution. This year, again, the district has decided that it doesn't want to be a part of that. And I understand that. I've had my conversations with you. I understand the risks. I understand all of that. What the AOA is attempting to do as the Landowners Association is to have that safe spot inside the park for Halloween that essentially solves one part. Actually, it solves a couple of the problems that we've had traditionally. One of the problems traditionally is that when the park was not open, we had people climbing fences, going into the park, playing on the playground with no lights, climbing on top of the pavilion, jumping off, dirt bikes in the park. We had no police officers then. The park was closed and people still went in and did those things. So it evolved, and Rob can attest to this because his year when he was the district manager, the board voted to close the park. And we had some construction that was going on in the park. And then they had these lights there. They ultimately ended up turning on those lights because there were so many kids inside the park. And that was a big concern because we had staff that were there hosting the ITID tent. So then subsequently, the board agreed to open up the park to create a safe place inside the park. And quite frankly, I've heard great things about what the park did. It's been positive. What the staff did. Okay, it's been positive. What people do on their private property, what they decide to, what people decide to do, period, we don't control, and we can't control every single little thing. This is Halloween. The reason why this has evolved as a organic event is because we live so far apart. There is not a place for residents to go, take their children and walk house to house. Like I was when I was a little kid, you got a pillowcase full of candy and you only went around the block. Here, you got to walk 10 miles to get that. Okay. So that's Citrus Grove is organic. The event on Citrus Grove is separate from what the ALA is doing. What they're attempting to do is essentially what the district was trying to do in creating a safe spot inside the park for little children and even for the teenagers for that matter. So talking about all these potential things that could happen is a very dangerous slope because I'm sitting here and what I'm hearing is if we're going to use that, then we need to deny the permit we just approved for the dance thing and every other permit that comes to the district in our parks. We have a 5K event that you host for Barky Pines. There is, in that park, not even supposed to be animals in it. But we have a 5K run where animals are in it. So not for nothing, we are shooting ourselves in our foot by trying to say there's all these concerns and the district shouldn't be involved in this particular event. Why? I don't know, but we should be doing all these other events and supporting it.
Well,
So
may I
I
for a
would like us
second?
to get back to the fact that this is a permit request that has attempted to solve all of the concerns that staff had. It took out anything to do with the street. It took out all of the things. It even agreed, initially they were planning on only 2 police officers at $65 an hour. Subsequently found out it's $88 an hour, and we're having to agree to potentially 6. Okay? And we don't even know that we're gonna have 10 children in there. We don't even know what we're gonna have. Because the other thing is it's now September 20th and they haven't been able to plan anything because we have to have board approval first. So that's where we're at right now. I think we're belaboring this and quite frankly, it's raising all kinds of concerns that if we're going to deny this permit, we need to be looking at every single permit, every event that we're inviting into a park.
I think you're comparing two totally different
I
animals.
don't think so.
I do, because you're talking about thousands of people and inside the park. I don't know if you were there last year or the year before.
I've been there.
There was
was not there last
how
year, I've
many,
been every year
how many people did we
since
have?
2011.
So you're comparing 100 people or less. And you're also comparing the permit that we just approved, which is during a district function on top of it, where the district does have control. So you're comparing apples to oranges, and I don't appreciate that. The Christmas, it's on the same date as the Frontier event.
It said that,
It's,
I thought you said that was in lieu of.
It would have, the district's event would take place right after that. It's always been kind of connected. That's just the way it's been. So
Connected to what?
they would have
They're
their little
part
thing for
of-
about an hour, and then they would go and join the actual parade, and then they do their performance after that. That's the way it's been the last 3 years since I've been here 4 years, but we've been doing this way for 3.
And the ALA was the one that used to host the events. So,
but they haven't.
Is there,
because they've been told they can't.
No, that is not true.
Yes.
That is absolutely not true.
Anyway, I'm not gonna get into this argument right now. The point is that what's before us is a permit for the ALA to run a Halloween in the park. They're not running Halloween on Citrus Grove. They're running Halloween in the park.
And nobody is telling the residents along Citrus Grove that they cannot set up and have their Citrus Grove. So that narrative needs to change, because nobody has ever said they were trying to stop that.
I am not creating any narrative.
I'm not saying you. I'm just saying in general, we're not trying to shut down what the residents want to do. What we're trying to do is to protect the district and all 45,000 residents, the staff and the board. And we want to make sure that the district is protected. This is not a small 100-person, 50-person event that we normally see. Even when there were concerts, how many people did we have? We didn't have thousands of people. We anticipated last year, what did we see? About 3,000 people. That's
total.
right. And there was drinking and everything else. That doesn't,
At
always
people's
go
private
on,
Property.
but it carries over.
I'm
And
sorry. Where
Go
they
ahead.
sent, where was the drinking for, which event was that for?
Halloween.
That is on this, in the booths themselves. Those are at the trunk or
That has nothing
treating.
to do
and it's-
with what people are doing.
I think the issue is of what's happening out on that street. And then having an event that could possibly tie the district into it. If something happens, they're going to look for who has the deepest pockets. And that's
That
the
doesn't mean
issue.
they're going to
And
be
that's where we have to
successful.
make sure it doesn't, but it doesn't mean that they won't be successful. there is a good chance they could get a jury that would sit there and say, or our insurance company would say, you know what, we don't even want to fight it, just pay it. And then it leaves us susceptible and hanging.
I'd like to make a motion to approve the agenda with legal doing the correct wording to protect the district from someone getting hurt.
For the indemnity.
Yes.
I'll second it.
Because there is an indication.
Yes, it's written right in the permit.
Hold on. Through the chair. It was mentioned earlier, like having a crowd control plan. Have they offered a crowd control plan?
This would have been, these kind of parts would be something we would ask for through staff and legal at the end. So as soon as it's approved, it'd be items that we would need to have to proceed the rest of the way. So if we didn't receive it, we would have to deny in-house at that point.
I feel like that should be, I know we're 0 hours and counting here because like you said, we're what, 6 weeks?
Answer that,
Yes.
some of that question. We've been in constant talks with Burgess about this. I will tell you right now, whatever staff is needed to be provided for this event will be provided. Like I said, whatever they need, will get. And I'll tell you one other thing too, and this is not, has not been a quick decision, but whatever costs associated with law enforcement will not be passed on to residents. We will take that. So we'll provide whatever options are needed for this. So that's not to be worried. That's nothing you need to worry about. We talked outside of the park, correct? Whatever options are needed to provide for these events, they provide. In the park too? Yes. It's good.
Thank you.
So does that mean? So does that mean?
But yeah, Burgess.
They're gonna work it out.
Grove have spoken
It's gonna be subject to.
several times about these plans. Sergeant Grove worked the events the last 4 or 5 years straight. He's very familiar with how these operate. And if you move it into the park, he'll have no issues bringing his guys in, walking through the security plan. He does all my operations like this. But he's the one operating the purchase and whoever, or if you're gonna come in and talk to the parks guys or whoever, if this is approved, I'm saying, then we'll take care of it. You don't have to, we'll take care of the security side of it.
Thank you.
So I have a question. Okay, so we've had all these conversations, yet staff recommends us to deny it. Tell me why.
That was the other permit. This one, we don't have an opinion on. That was the original permit that we were denying.
Under
Under the
because it
original.
brought ITID into it.
And it also focused
This
on
is-
Citrus Grove and
this-
Citrus Grove Boulevard.
Through the chair, sorry, can I? Yeah. So just quickly, so we denied the permit because it tied the road, what was going on with the road into the park. It was a combined event that was being, they were talking about, closing down Citrus, doing things like that. This is very specific to just Citrus Grove Park, and that's been our issue. There's still, as Andy said, there's still issues, there's still liabilities, but it's up to the board at this point to make a decision. What staff did is we brought something in May for the board to consider. You guys considered it, then we brought it again last month to talk about closing that park down entirely the day of the event, because while I agree, nothing has happened there, and could something happen? Nobody knows, but if something does happen and you have 3,000 people, your odds, the law of probability eventually catches up with you. So that's what our concern was. That's what my concern was with this event in general, because when you look at Sunfest or any of these other events, you look at the amount of security, what they have set up, and then you start looking at these events and what's been happening, at the South Florida Fair, how they've had to change their policies even during the fair. They changed them. So that's what my concern is, because that's the age group, as Mr. Lawrence said, between 8 and 9, as it starts getting dusk or dark, that's where you start having some issues. And that's what our concern is It's not about the event. It's not about trying to shut the residents down. And I'm trying to do the opposite, because if we get involved, a government has to control it, because then, you know, liabilities and then we get into the situation. I'm not exaggerating, you know, maybe you, maybe me, maybe him, we could be held criminally negligent if something really went wrong. And you know, it's rare that that happens, but you know, if something really happens bad, you know, you can see what they do. And it's happened, you know, where they pursued police officers and things like that with school shootings. And so for not carrying out their duties, or, you know, in this case, we just have a lot of concerns. And in order to control, not control, but in order to try to mitigate those concerns, the level of resources that we would have to put forward, it wouldn't be financially feasible. And I think it kind of defeats what the residents originally wanted. And I understand why we went in there, but whenever we started opening up that park, you know, you had maybe 1,000 people there. And I know some of it was during COVID, but now you're having people coming from everywhere. They don't understand our roads. They don't understand that there's kids riding horses or dirt bikes or ATVs or whatever it is. So I'm just concerned about all those little things outside of that park coming back onto us. This, you know, from my standpoint, if the board wants to do it, I think legal has reviewed it. They feel suffice, and Aegis does. So we just aren't going to have an opinion on it, because I don't want to say we recommend it, and I don't want to say we deny it. So we've made what our concerns were, and now it's judgment of the board.
And how many volunteers do you think would be needed to control if all the people spill out off the street into the park?
Well, I think a lot of that will be determined through the site plan and how they determine what they're going to be offering in there, things of that nature.
And has the ALA worked on the site plan yet?
Well, I don't think they probably have not, because we've been working on just this concept to
Right.
get it here tonight. And that's why you don't even really have anything in front of you. So this is a work in progress, but we have worked with the ALA in the past in trying to develop site plans, but this one, they'll have to be kind of on their own. Because we're regulating it now. In the past, we've always kind of partnered and moved forward like that. So in
So
this
they're on
case,
their
we
own
can't
for
really-
that, because if
Yeah,
we get
but
involved, then we're,
Yeah, but
Right.
it's not that difficult to put together a site
Right.
plan and a volunteer layout of, you know, you need this volunteer at the gate for the parking lot, this volunteer. So, but that's up to them.
right. And what about other background checks needed for those volunteers, even though it's not for the district?
I believe that's.
Are we requiring that for every other permit that we issue when somebody rents a park?
I think our experience has been with district volunteers, so we can
This
set.
is not a district volunteer.
Yeah, so we can set the standard for district volunteers. So, you know, again, I think if you.
So outside, we don't need that.
I mean, it's recommended, but I mean, we're to discuss on the agreement, what the level of involvement and like the requirements are going to be. You know, I don't think it's something that should be required. I mean, it's a best practice. But to your point, it's like, you know, I think where you're going with this is, are you treating the ALA differently in this particular event than you can treat other organizations going forward? I do think this event is different.
Right. It's not who's putting it on, it's the scope of the event itself.
One question that I think you were, I'm sorry, Ms. Burrell, you kind of mentioned this about the drinking. You said, you know, something you have to consider is like how foreseeable a claim is, right? And that's a question that if there was a claim is going to come up. This was foreseeable, therefore you should have been proactive in doing something to prevent that from happening. And in a case like this, you can say that, well, it's foreseeable that this park is dark, that there's a lot of kids running around, that something could happen. So because of that, this makes this event unique where you might want to have the requirement for, level 1 background check. But at the end of the day, the district they're not district volunteers. It's not a district event. So what are the requirements, the minimum requirements that the district's going to include in that agreement for anyone to use their cars? It's similar to insurance requirement, right? You may have a $1 million general liability limit that's standard across the board, regardless of who is renting the facility. But if you're gonna have a Ninja Warrior competition on your district, then you might want to bump that up from 1 million to 5 million, depending on the exposure.
Right.
So you make those requirements based on the exposure that you feel that event is creating for the district.
And who would set that standard? You or our legal?
I mean, we can work with district staff. Ultimately, it's up to the district, but we can make a recommendation based on best practices based on all the other districts that we work with and what is reasonable and has worked in the past, right? We also work with 300 public charter schools, so we have some experience when it comes to the background checks and events like this to ensure the safety of the kids that attend, right? And in that space, we always make that a requirement, right?
Right, because this is kids, right? But this is a kids event. This is not an adult.
Children are involved, I mean, with any time. I'm sorry, that's something where we normally don't compromise. When children are involved, we always require background check. Sporting events, anytime children are
I
involved.
mean, we did it for the Santa.
Yeah, anytime children are involved, we require background checks. That is a safety issue. I mean.
When the
that's
district
okay.
is running an event. So,
But you
so
have-
I'm going to, again, reiterate, this is a permit. And you need to be careful what you're saying we always do, because we do not, when we issue a permit, require people who are renting a park to do all of those things. We don't. You haven't required it for this other that we've issued. And as far as I know, they haven't required it of anything else that we've issued this year. So, if the staff think that that is something that is necessary, it needs to be brought to the board as a recommendation and adopted as a policy that we are consistently applying across the board and not selectively.
Through the chair, I think there's rentals and then there's event permits, and there's a difference. And that's something we should look at for events, like a birthday rental or something like that. You don't really need to go through it.
Right.
But, again, I don't want to belabor the point, it's the board needs to decide, do you want to do this permit and what are the conditions? We laid out what we felt were fair conditions that further protect the district and try to keep an arm's length separation between the ALA not being a service provider, being an independent entity, and the district. And again, our biggest concern, my biggest concern has always not really been about what goes on within the park, what goes on once you step outside of that park or somebody steps from that event into that park, who, might not be stepping in there for, could be stepping in there for nefarious reasons.
Can you get with the ALA and talk to them about a single event policy to cover them? That way.
I think the ALA needs to do that on their own, because you can't have our insurance agent, because you're tying us back into it.
Y'all get in touch with an insurance agent and get a single event. Okay, well, you got a policy in place.
Yeah,
It's
already been discussed and they know about it. We have a copy of their policy. We said.
Okay, so that
Well,
helps
this is
with
the
the
first,
adapt-
we're learning of it, so
Okay.
this
The
is
policy
new
is-
information.
I don't know why it wasn't provided to the board, because it was given to staff on Monday.
I can't answer that.
Second question, Captain Turner,
Yeah,
do y'all still have the police cadets?
we do.
Is there any way that they could volunteer for this event since they already are vetted?
Well, we're working on volunteers. It could be them, it could be the MERT people that we have. But once we get an idea of numbers and everything, then I'll look that up.
Thank you. That's helpful.
Through the chair, I
Hold on,
believe,
Patty, let Patty go. She's been waiting, so.
I believe we have Bob online
Okay,
who can address the insurance question.
go ahead, Patty.
I just want to confirm. So the district will have no employees there, like nobody's
Correct.
going to be there to check the bathrooms. No, so no staff will be on the property during this whole event.
The only plan would be to have either myself or Mr. Sisolak show up in the beginning just to confirm that the site plan, like the vendors that are supposed to be out there are the ones that are out there. That way we know we have the insurance for it. At that point, we walk away.
Bob?
Is he online, Bob Morgan?
Hello, yes, they just unmuted me.
Bob, can you address the insurance?
The insurance covers any event that we have, alcohol or not, as long as it's not equestrian, which requires an additional rider, and it has additional insured for the Palm Beach County and the ITID. If it needs more than that, I asked a week or two ago what I needed, and I've yet to hear anything whatsoever about this Halloween event.
And Bob, has anybody communicated to you any additional riders that you need?
I haven't heard a word from ITID at all about this, other than on the last meeting when they said they contacted me about this, and nobody contacted me, which I showed you a screenshot of the emails that I've received from ITID since August or July. No, I have not heard a word from ITID.
All right, thank you. I believe that they did tell Lou during the conference call, and it was asked that that be sent because we don't know specifically what needs to be asked
One
for.
rider they talked about was the child molestation.
Right, but I don't think that's what it's called. So we need to know specifically, and staff needs to communicate that to the ALA.
Can we call the question?
I think we have to ask for a public.
This is the coverage here.
Probably did.
No, not yet.
This is the
Yes.
coverage here.
It's 2 million aggregate.
Can you see it?
Is there
Yeah,
public-
this is the certificate of insurance. So we have the actual copy
Does
of the
it-
policy.
Does it need to, in addition to the district, have staff and the board added to that?
So, we normally include staff, employees, agents. And that language is included in the indemnification language. The contract's going to specify exactly who needs to be listed as condition insured and the certificate holder on the certificate.
And we've only ever required it be in the in-trail improvement district.
Yeah.
So again, if we're changing that,
Well,
it needs to be.
Yeah, so I'm not quite sure what's done in the past, but the standard practice is that you know, to protect the board, in case as you mentioned, that is the district, the board, employees, the volunteers, agents, and sometimes it includes, independent contractors on behalf. Now, I think that's something that can be negotiated. I don't know in the past how it has been handled, but normally those notifications, that language includes anyone associated with the district.
Yeah, I would want to see that for sure.
We have public.
We do. Any
Do we
more
take a
questions?
motion? I'm
The
calling
motion is made.
the
Betty
question.
made the motion. Oh, we have public comment coming up now.
Just
Oh,
through the chair
sure.
before that. So can we have that with the conditions that Mr. Lawrence laid out? Because he just said approve a permit, but. there's
Right, no, we have to,
conditions
right, we have to add the conditions to that.
I know my motion to also include those conditions.
Which condition?
But we gotta say specifically.
Yeah, that's why I want.
Kathy, can you?
Yeah, let me stop sharing and go back into this other screen real quick. I have kind of an outline. So you can see the district requests right at this point. And these are the items that we kind of added into it.
Do we need to use all the bullet points?
No, just the area where the district requests are.
The special event requests are already in the permit.
This is just the items in addition to what He's already-
and they already said they don't want alcohol. I mean, the only new thing here. And again, I don't know why you need a site plan as part of a permit to rent the park out for what they're doing, but anyway.
Because that's how we know for insurance, and that's
what vendors are on site, so we can confirm that
The
the vendor
vendors,
that we
the vendors
receive.
themselves have to have individual license and insurance. It's standard.
Correct. And then we'd have that list, either, we would need some kind of list to know who's supposed to be out there,
And
basically.
that we have already cleared their insurance coverage. It's no different than when, like, I have a contractor that has subcontractors. We make sure that their subcontractors have given their insurance to us so that and that we're certificate holders of that. So
Correct.
those
It's
food
the same
trucks would do the same
situation.
thing.
It's already written right in the permit is what I'm telling you.
But-
You
but-
actually have the permit in front of you. It specifically says licensed and insured and on the district's list, approved by the district.
Okay.
But
The
that's
other thing is that the permit should not have the additional officer
No,
for
because he already
ITID.
said that.
It should, no,
No.
it should, again, we're trying to take the district out of it, but the district is trying to control
This,
the event.
that, these are my notes.
We're not trying to
Miss-
control the event, but actually the opposite.
So wait, so
That,
you
those were my,
just-
these are my
They do that.
specific notes, that wasn't a request on your permit. That was something that I just had there to just speak about, basically.
As a separate item.
This is just bullet points for me to be able to discuss.
Okay, so I need a memo
Yeah.
motion
So-
to
So
include.
just-
time out.
through the chair. So the site plan also helps PBSO because God forbid something happens or PBFR, they know where certain things are. Because when you have if there were a mass incident, they know, okay, there should be a food truck over there, or this is where the tents were giving out candy, blah, blah, blah. That's why you
Right.
have that.
Again, this is not a
So it does
small
not have to be
event.
an Engineering plan.
Right.
It's basically a
A
satellite
layout.
image that just shows trick or treat will be here, food truck will be here, bounce house will be here. And that just, it helps. And that's why they require, but it also helps them with insurance because, no, this is where we said we had it. And so.
So are you talking about on the district request, the last item about the PBSO officer being there from 10 PM to
Yeah,
2 AM?
that should be separate and apart
That's-
from the.
Okay.
the
Like,
But
permit.
we were making
Okay.
that as part of a.
That was
condition.
just a
Because this is
discussion.
just my
Okay.
bullet point notes.
But
Gotcha.
Captain Turner already said he was gonna take care of that, so that's.
Yeah.
Okay, so I.
Okay, so.
He made the motion.
The waiver of the fee.
Okay. You
And-
make the motion.
No,
No,
you
You
make
make
the
it.
motion,
You
so
make
you need to.
Okay, I want to.
I'm gonna suggest an amendment to include. So the motion is to approve the permit as submitted, which already has the indemnification, the food truck, the bounce house, and PBSO recommendation for officers, if it's still needed. So that's already in the permit. And then, if we can add a fee waiver. Limited controlled parking in the park
For ADA.
for ADA.
And also
and-
to eliminate the district will supply to one additional office.
No,
That's to be removed.
I'm,
No, but I'm eliminating that from.
Just let her.
just let me do it, okay? Limited parking and extra restroom facilities. Okay? But the restrooms will be open, correct?
Correct. And they,
Okay.
and the park will be cleaned and maintained like normal, and it'll just be like a regular
Right.
rental would be.
Okay, so I believe the indemnification's already in there.
The site.
And to provide a site plan within 2 weeks from today's date.
Yeah, and it takes like an hour to create one real quick.
Yeah, we just, yeah,
Okay, that's the motion.
that's the motion.
Do we
Second.
want to clarify no district staff?
At least
Again,
verbally. I mean, if you guys want it on the permit.
we do not provide district staff for a regular permit. or
Exactly.
Event
Okay.
unless it's specifically part of the permit, so.
Exactly.
So that's the motion, that you made the motion, I seconded
Okay.
with those amendments.
All right.
Oh, and adding the rider recommended by Aegis Insurance regarding the sexual, what is it called?
Sexual abuse molestation.
Sexual abuse and molestation is the name of the policy rider that we need to request.
So different carriers call it, sometimes they call it a battery. But in the insurance industry, it's called, SAM. That's,
Okay,
I have a question real quick. As far as the insurance, and I didn't see it on there, do they require the automobile insurance as well? This particular thing?
The
That'll be the food trucks would
is covered
provide
under the
that.
Food truck
Yeah.
insurance. Okay, so that it includes the rider.
Okay.
So I second it.
Public comment?
We
Yep,
do.
we're doing. So
Yeah.
I'm ready. Mary Ellen Doherty.
Seems like I have a lot to say today. I really have to apologize for everything that this Halloween has turned into. Myself and two other ladies actually started this thing we were here 2 years and we went to La Mancha and we just hated leaving our community and having to go trick or treat somewhere else. And we just wanted an old fashioned trick or treating. So we used to make flyers, our children would make flyers and we would hand them out at all the football games where our children played football here at the community park. And it turned into a beautiful thing where we had trick or treating on our street. It never was intended to be food trucks and all of this. It was always just to invite everyone to one block because as Betty mentioned, we are not a regular community. You can't go trick or treating. Everyone has a fence or a dog. Just to walk up my driveway alone is a hike. I have it every year. I invite people to my home. We set up at the curb. We give out buckets of candy this deep. We spend an awful lot of money. We decorate the house. And I know a lot of other people on my street go all out and really love it. But all of this food trucks and porta potties, I mean, I'm old school. I went trick or treating and there was no porta potty for me. And if
Right.
somebody really needs to go to the bathroom, I've had people actually ask me to use my restroom and we escort them in and let them go to the bathroom. It's supposed to be a community. What it's turned into is not that. We're supposed to be bringing our trick or treat to one street, bring candy for the children to hand out. People are supposed to bring candy, bring their pumpkins, bring a tiki torch, set up along the street and make a nice time for children to have fun, not for people to go on top of the pavilion or destroy fences or any of that. And I apologize that it's turned into this absolute nightmare. And
You
I
don't
know
have
how
to
we could
apologize.
reel it back to the way it was. It was really a wonderful
I
experience.
would like to say my children have enjoyed many years. And I used to love taking pictures and showing how our community got together and did a block
Yeah.
trick or treating.
And
So
that
I
was
agree
just
with
3
you.
ladies,
Yeah.
myself and 2 other women who have since moved away over the years.
Thank you.
But
Be nice to
it
bring
was a great
everything back
concept.
that
and
way.
Now I don't know what. I
Yeah.
wish we could just
Yeah.
bring it, like, we don't need to make money. People are there making money with the vending machines. Vending
not-
things. I mean, do we need vendors to make money? We're supposed to be giving, not making money there. We're supposed to give things to people. Okay.
Through the chair, I just want to say the whole purpose of the food truck really was, and I've been going to Citrus Grove Halloween since 2011. And the whole point of the food truck is that there's actually people that set up barbecues along the street and cook and whatever would happen every year when I would go with my kids is they'd be hungry and because they smell the barbecue.
Yeah.
And there's nowhere to get them anything to eat. The food truck is inside the park. It's not on the street. It's inside.
No,
the
but it
park.
seems to be creating such legal issues that I
Yeah.
really feel bad about it. I personally hand out meatball subs. I make meatball subs and hand them out.
What's your address?
I've been doing that for many years, the whole entire time.
Your
And-
shirts?
Ah, there you go.
They can
But-
sell you a policy.
I don't know what to say. I just wish that we could get back. I mean, I know people that I know love the little hayride thing that we used to do. That was really cute. And I just feel like we need to reel it back a whole bunch because personally, we get less people down. I live on Citrus Grove and Hall in the second house in from the corner. And we used to get a lot of people down by me, but now we still get a good amount, but down by 100 by the park, when you cut it off of there, what street is that, 140th? When they cut it out at 140th, a lot of people find it very difficult to to do the trick or treating when you start to cut it off, and then it's just a big mob down at the park instead of a whole block worth of people. We're supposed to be a long route for children to really get a trick or treating experience and go along
Yep.
and do that sort of thing. So anyway, thank you.
Thank you.
On the tails of her, I would like to remind people that bring their children to trick or treat, bring a bag and give these people that are bringing up a few bags. And this way they can continue handing out instead of running. I used to do that. I would bring when I saw first participant was low, I'd give them a bag so they could keep going. So just remember that, just kind of give back to the community. So the next one I have is Karen. I can't make out your last name because of an M. Yeah, okay, there you go.
I think it's a good idea. I think you're gonna have a risk no matter what. And if you're trying to exclude, to kind of separate from this, this is a good opportunity to let ALA go ahead and do this. There's always gonna be a risk. And I missed all pay rides and everything, but yeah, things have changed. I agree with you, Miss Betty. Betty Bum. No, seriously, I think
It's the
you have to-
forecast.
You are gonna live in
Snow tonight.
Just put it
you
on
have
your
to
mind.
streamline it and let it go and go ahead and let ALA grow. I know, I kind of. And it's a good opportunity to start requiring the site plans and everything to go on with it. Get them to make sure their insurance is high enough and kind of let it go. And then you'll find that, things will work out a little bit better. That's just thanks.
Thank you.
Thank you.
Through the chair, before you call up the next person, is it okay? You don't have any more questions?
You wanna
for
leave?
Andy or me, right?
You're not enjoying this?
Come
I
on.
don't
See you
get
guys
it.
later.
Yeah, nice try.
It's only 9:30. We got like another hour.
Make sure you visit them on your way out. I recommend them.
We'll see you at the Halloween one.
All right.
Thank you.
I appreciate it. Thank you.
P.S. Scorin, sorry if I.
Full disclosure, I'm not an attorney. I'm not an insurance expert, but I am a business person, and I will tell you that the more information that you provide on this permit, the more requirements you have, the more responsibility you have. So when they go to sue you, they're going to say, you enumerated all of these things, but you didn't put this in there. Why didn't you? So just be careful. That's number one. Number two, I think what you have to weigh is your liability greater by not doing anything or by doing something in that park? You've all said that there were issues in that park, that was what the ALA was trying to cover for, so that you don't have people unsupervised in there. So to me, I think the decision is between, is my liability greater if I don't do anything? As your insurance person said, what was foreseeable? So if it's foreseeable that you're going to have people in there unsupervised, then you're better off covering your liability and having it be supervised. My 2 cents. Thank you.
Thank you. That's it.
Thanks. I do have one question. Since we last meeting made a motion and was approved to shut down this park, do we have to do anything to reverse that, or are we just good to just approve the permit?
I think you're fine to, approve the permit.
Michael? Ready? Okay, let's call the vote. All in favor?
Aye.
I don't know. I don't know how I still don't know how I feel about it because I still feel like there's way too much liability.
Through the chair, just
I'm sorry, for the record, we haven't finished the vote yet. No. Did you?
No, I
No,
haven't
it's not.
voted yet, so.
Did
hold
you
on.
go?
Kind of, sort of, yeah.
What do you mean, kind of?
I'm not full hearted on it. I just.
Did you want to say something, Burgess?
oh no, I'm
They
sorry.
still haven't voted.
Yeah, I thought they voted, so I apologize. It has nothing
I-
to do with this.
Here's, I would say with the items that have been marked down, as long as they meet all of that and they're able to provide the volunteers and the officers are willing to to provide the service.
My concern is the exposure. So if we're confident that the district, the staff and the board don't have exposure to anything that happens, then I'm not 100%. I understand that, but like you said, if we know could be issues and we go ahead and approve it and those issues happen, then we know going in that something is going to happen. How does that make us liable? Mary,
We actually checked on this because we figured.
Thank
the question
you.
Might come up.
thank you.
And it's Florida statute 768.28(9)(a). And the question for, when we talk strictly about the separate permit, if the event is with the scope of employment, like of a employee or function, government employees, officers, or agents are shielded from personal liability for tort claims arising out of their official duties, unless, and this is where the unless that you're concerned about, unless such officer, employee, or agent acted in bad faith, with malicious intent, or with wanton and willful disregard for human rights, safety, or property. If the employee's actions during the event are deemed reckless or intentionally harmful, this protection will not apply. So the standard under that particular statute is that there has to be a showing of bad faith, with malicious intent, or with wanton and willful disregard.
So by approving this, we're not showing any of those things, but it's not a staff event. So does that still
No,
apply?
it's within. If it's considered as part of your consideration for the things that you approve, if it meets, as long as it doesn't meet that, you should be.
Okay. And you'll pay my legal fees if somebody sues me.
I'm just advised.
We'll pass the bucket around.
There you go. Okay. Yeah, there you go.
Okay.
They take 7%. You don't want to do that. Okay, so Patty,
I'll say aye, only because of the parameters that they have to meet.
okay. Well, it's gonna pass, so it doesn't make a difference how I vote anyway.
But it
So-
does, you need to
Yeah,
vote yes or no.
Yeah,
for the record.
I'm aware, I do, but it's gonna pass, so, I don't know, I'm just not comfortable. I'm really not comfortable with this whole thing, and I'm gonna,
It's 4-1.
and
Let's
it's
move
4-1, I'm gonna go with my gut. It's no offense to the ALA or anybody, and I don't mind, and I don't, anybody doing their thing on their property, have at it. I wholeheartedly agree. I think it's fantastic, but I'm just very concerned and I can't. Just can't in good conscience. All right,
So
moving on.
through the chair,
Mhm.
I know it's not on the agenda, but I would like the board to consider the withdrawal of our ITID event on whatever date it was, October 26th at Nicole Hornstein or ACP backup. to
I'll make the
send to
motion.
June. Thank you.
Second.
All, public comment? Seeing none. Okay, call the vote.
Aye.
Aye.
I'm saying nay, because that makes me upset that we're not doing a community event now.
I agree. But we're gonna throw the baby out with the bathwater. It is what it is. Less work for staff to do. Michael,
Yay or
you
nay?
you wanna kill the district's event for the little kids? Keith? Okay, so. Yeah, I think I'm a nay too. It doesn't matter. It's gonna pass.
Did you vote?
3-2.
3-2.
Yep, 3-2. Okay, all right, moving on. Consent agenda. Do we have a motion to approve?
I make a motion.
Second.
I have a question on one of the consent agenda items that I just noticed this one here. Um. Can we just pull 11.4 for discussion?
Okay.
11, what? That one, there was just additional backup with the award number changing.
It was based on the federal number and it was.
So it's just correct.
It was totally the number.
Okay, so do we want to address 11.4 first, or do we want to move the rest?
I'll make a motion to, well, I just have a question, so let
Okay.
me just ask. the
Okay.
question. On the organizational chart and the salary schedule, what changes have been made on here? Can you just summarize that? Because I did not have a discussion with staff on this and I didn't even look at it, to be honest. So
Yeah,
I want to know.
Chair, we were, during our presentations at the budget workshop and then the budget hearing, we really made no changes to the organizational chart, and I don't think,
No, on the salary ranges, we just changed the on the executive level, we changed the
That we already approved.
yeah, we already changed.
And so
On
by
the org
approving,
chart, the only thing that I changed the picture on the finance. committee.
you can change mine too.
Well, we
On
move
the
on.
merit increases, are we approving that at this time?
Well, yeah, it's been approved in the budget process, the 5% anyways. So yes. we
Well,
approved
no,
it.
it was part of the budget, but the board has not yet approved it. So that's why
Yeah.
I want it to be very clear that we're approving a 5% merit increase.
up to five.
Right.
Up to 5.
Yeah, up to
In the past, it's been 3.
last year was 4.
Okay, each year it's getting higher. So, and we did it because there was inflation and now we're on the downward side of that. So, and I'm just wondering why and we've moved positions around and done all that. So can you just give me a quick sentence why we need to be going to 5% right now?
Stay competitive with the job market for heavy equipment operators, because it is, and we're gonna, as I said during the budget presentation, I think at some point, we're gonna have to start shifting from in-house work, capital work to contractual work, even though it's gonna be more expensive, because we're not gonna be able to necessarily get the level of employees that we want. So we're not there yet, but as this generation, we just had a couple retire recently, and there's very few that are filling in those spots at a younger age.
And we just recruited some new talent. And I want to say that our staff, the district staff, they are tremendous asset. The district.
I'm not
will
saying that they're not.
definitely- Yeah, they will definitely, you, as the board can definitely say that the training that they have, we have now almost no vacancy left. And they are out there and they're getting picked up and they are not jumping because they know what they have here.
So in the budget, we put 5% merit rate. Was that on the whole?
That's calculated on the whole staff.
So the budgeted amount was based on funding all of our staff positions, but the report here says that only 25% of the workforce is currently eligible.
Yes.
So do we know what the numbers are?
No.
Because that other 75%, I want to know what that number is and where we're moving it, because we put it in the budget. So that's a significant amount of money.
I don't understand.
If we budgeted 5%
Yep.
merit increase on our salary in the budget.
Across the
And
board,
across
she
the board,
means, but we're only
And
doing
now it
25%.
says that only 25% is currently eligible.
25% are not.
Oh, currently not. Okay, so
Yeah.
still
Yeah,
25% is a significant amount.
Well, the
Right?
other 75% are in the probationary period, like.
I understand, but
25.
I want to know what the amount is, and I want to know what we're doing with it,
We'll get
because
that.
I've been having some discussions with staff. And, it seems we need to have a discussion about mowing operations and sufficient mowing and, or figure out a path forward on that that's currently not working. And so if that's some funding that we can use and talk about as a board, then maybe we do that.
I believe that, as part of the budget, workshop, didn't we show like what other cities were given and it was 6 to 8%? So, and I understand they're cities, but they're still in our marketplace, so we're still competing.
And we'll
against them.
lose to, right.
Hey, I'm not arguing that.
No,
It's
I
just that
understand.
everybody is hurting
Yeah.
and our justification for continuing to give high was because of those things, but we're now down, coming on the downward side of it. And so we need to be tightening our belts. I mean, we already have. I'm not saying we're not, but okay, thank you.
Okay.
So I'll make a motion to approve the consent agenda. Items 11.1 through 11.9 with the modification to 11.6 that was added to the agenda at the beginning of the meeting.
Second.
Okay. There's no public comment on this, so we are good to call the question. All in favor?
Aye.
Okay, see that it passes 5-0. Staff presentations, Mr. Hanson?
I didn't call. Yeah, we sent them to you too. Yes, sorry. So just, I'll be quick. So one of the things that we'll be working on and with, especially with my trip to Tallahassee recently, is really trying to receive funding. As you know, the Fed today announced that they would be cutting, I think it's 50 basis points, and they plan to continue that through next year, actually through 2026, and they were somewhat non-committal on 2027. But what my hopes are, we get the geotech back soon and we start meeting those conditions, and so we can, by the end of next year, try to go to market, to at least to the bond market, if the board wants, to start at least on the surface levy and try to leverage bond money, federal money, and state DEP, which is environmental protection monies, as well as any other sources that we can find to try to at least start on the surface levy. That project cost, I think you said, was approximately $20 million, but that would not be doing any dredging or anything like
So for
that.
20 million.
Yeah.
Is
For
that
once-
doing it in-house or contracting it out?
That usually he makes those things based on contracting it out, and then we come back. And now we're required to by state law to show, what the cost would be, but sorry, I think you were getting ready to.
You answered it.
Yes.
But that's 20 million total. Hopefully we can get grants and other.
It's gonna be more than that. And the other thing is that as soon as you get into some of those grants, especially the federal grants, it costs us more money. So sometimes we have to look at where we're asking for that money, because if it ends up costing us more money, is it really worth it? So,
Wow.
it's the only thing.
Yeah, if we're doing a few $100,000 or even $1 million, I'd say forget it. But for something like this, you're talking that you could potentially get millions, but we won't know that until we get deeper into it. But
Resiliency funding.
Yeah,
Are
oh,
we
yeah.
eligible to apply for that now
we're
ourselves?
now eligible for resiliency, and we're now eligible for grants, which is my segue into my second thing. You don't need to do it next month in October, but November or December, the board needs to start, or whoever will be on the board will need to start thinking about what you want in your legislative priorities, with the, because one of the things that I've noticed is a lot of these grants, including resiliency, they want the terms clean water or water control, and even our charter doesn't really address that. And that's something I know you and I talked about like 3 years ago, 4 years ago even. So what you may want to look at is, adjusting that, the charter, the legislative enabling legislation to include that we can do that. And that may open up more doors for us.
Well, aren't we required to do that under the NPDES anyway? We're required to keep our water clean. So,
Yeah, but they're not necessarily talking about just that standard. So they're talking about, so when our water goes through, our water is already clean, but we don't really advertise that, and we should be. But again, can we use funds to actually get it to that level that we may need? For instance, if we wanted to do an STA, something like that in the future, there's eligibility for that.
I have a question for Mary related
Yep.
to that. And I guess it's J two, because we needed to do a modification to the water control plan with respect to the 640 acres. Have we done that yet?
Would it have part of Frank? I mean, for the GL for the 640.
Well, I remember that when we were looking at it, it turns out that there was some things that had been amalgamated that probably shouldn't have been, like the M1 and the M2. Aren't they all the same plan for the impoundment?
I don't know, Jay.
So I take it that we haven't done anything on this.
Well, I'm
Because
not
remember,
aware.
we talked about amending the drainage plan, the basin plan for the
The M2?
40 acres for, well, it's the M1. And when you pulled it, it has M1 and M2. And there was a question about whether or not we had to separate it. And
Let me go from memory. As I recall, we have an M1 and M2 water control plan.
Right.
And I believe that the permit for South Florida was originally submitted combined.
And that was the very first.
We have also prepared a real preliminary resolution, but it never went to the board on 640. But it stopped because we weren't ready to go. So we don't have a water control plan that includes the 640. And we also knew and know that there are items in the water control plan that need to be modified.
so my question was going to be whether or not we came up with a solution to that, or whether or not we can just create an independent water control plan or have to go through the modification. That was where I was going, because obviously if we're thinking about bond funding next year, we need to be starting this and getting it done soon in order to be able to move forward on that. So can we bring that back to the next meeting in terms of the resolution to get that started and the solution that you guys came up with, whether it be,
I'm trying to recall the specific.
I'm sure when you go
It's been,
back.
it's been a couple of years. I believe that we can resurrect that. It might have been 3 years ago, but that we,
Was at least
it was a long time ago, but we can resurrect it and see what we have to do.
Jay and I.
I know there was some concerns about because if it's not M1, it doesn't benefit M2. M2 shouldn't have to pay. It should be separate, just like Santa Rosa Grove should not be paying for something that,
Now, I believe the original water control plan said both, but when they were actually developed, it was split.
But there was questions about whether or not we had to notify everybody if we did the major amendment. So that's what we need to fix.
This will be a
It
major
would be
amendment.
major.
Right, and if it's that we have to notify everybody in the M2 and Santa Rosa Groves, and they're not having to pay, they don't benefit. So that was the concern.
We'll have to get back with
All right.
the final on that one.
Thank you.
That's all for tonight.
Okay. Supervisor business, Michael?
Oh, good. Thank you.
Betty? Okay. Betty?
I just want to say that, I'm happy that, we got some things done tonight, and I think we have a lot of work to do in educating the community And, I know that staff is, hmm, I don't want to say overwhelmed because I know you guys, well, maybe you are sometimes. I think we're overwhelmed sometimes. But, I want to make sure that we have the right amount of resources going towards the things that the board has made a priority. And if we don't, then that is something that needs to be brought to the board. If it's something that needs to be approved, or if you already have the approval in the budget to be able to get those additional resources, whether it be, you know, bringing another law firm in to help with some things, or another engineering firm, or, you know, for, you know, there's any number of things I can think of with staff, but I think that we have to keep things. We need to try to get in front of things and not be behind. And so often, every single time I go through my emails, I'm finding stuff that, you know, when I'm looking for something, it's like from 3 or 4 years ago, and it's like, oh yeah, I don't think that was ever done. And we've done a lot. We've done a tremendous amount, but there's still a lot that we need to do. And right now it's coming at us fast and furious. And I want to make sure that we have all the resources and the best resources that we have going to it. Because everything depends on that right now. So that's all I have to say right now.
Thanks, everybody, for coming.
Very good. Okay, motion to receive and file reports.
Second.
All in favor?
Aye.
Passes 5-0. And that is it. Meeting is adjourned.